pay, wherein I'm supposed to receive an additional increments.
So is it, what is that? Writ petition?
Writ appeal, Mala.
Proceed.
My lord, one writ petition challenging just one writ petition challenging order passed by Justice Keshavanarayana Committee. Writ petition challenging order passed by Justice Keshavanarayana Committee, LIBDA writ petition, my lord. It's may be taken up, my lord.
What is the urgency?
Urgency is, my lord, committee has ordered the BDA to allot the sites in favor of the allottees within 90 days of the date of the order. Hence, there is urgency, my lord.
This is our jurisdiction, huh?
Yes, sir.
Fresh.
BDA, LABDA. Keshavanarayana Committee.
Please.
Which is, give it time. Give it. Don't do it. Give after 40. No, urgency in this.
Ballot serial number 17, and for appellate, R2 death agide.
Just
Now-
1 minute. Just hold on. We'll just call the list.
Yes, yes.
For adjournments, page number 6, serial number 27.
Your Lordship, serial 22, Your Lordship.
20.
222, Your Lordship. Kindly have it next week. Senior as well. I have engaged senior counsel.
Who appears for the other side?
State government.
State.
It is.
Is there? Now you appear for the petition appellant.
Yes, Your Lord.
At the request of counsel for the appellant, re-notify and give your convenience something.
511.
Serial 19, my lord. My lord,
Yes.
serial number 19, I am for the appellant, my lord. In respect of matter, my lord, there is a proposal being made before the statutory body, my lord.
What happened to the?
Settlement, my lord, settlement is going on, my lord, because the statutory government, ITA department, my lord. I
For the
need-
respondent, my lords.
You are for the respondent?
Yes, my lords.
The counsel for the party is still settlement going on.
My lords, I'm given to understand that a proposal is being given by BBMB. The talks are going on, my lords.
Then a counsel for the party state that the settlement process is still in progress. Adjourned to. Give it up.
Ballot serial number,
2210.
Ballot serial number 17,
10.
Publish, my lords.
Which number, ma'am? 17.
17, and for appellant, R2 ಅವ್ರ ಡೆತ್ ಆಗಿದೆ. LS ಅನ್ನ ಇದು ಮಾಡ್ಬೇಕು, ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು, ಸೈನ್ ಒಂಚೂರು
Who has
ಬಾಕಿ.
expired?
I'm for the respondent 1 to
Respondent.
3, my lord. And respondent with 2 passed away, and last occasion I filed a memo for reporting the death of the respondent number 2. They have to take steps for LRs to bring the LRs.
The- We can't hear this matter.
LS ಅನ್ನ ಬ್ರಿಂಕ್ ಮಾಡ್ಬೇಕು, ಅದು ಸೈನ್ ಬಾಕಿ ಇದೆ. ಅದು
Bring the LRs on record, my of the respondent number 2. Yes.
Pardon?
If it is required, then we can, otherwise we can close it.
We have been informed respondent number 2 has expired.
Yes.
respond to.
The appellant, the counsel for the appellant states that she shall take steps to bring the LRs of the respondent number 2.
2.
At her request, re-notify her.
27-9.
Much.
The lordship kind permission, my lord. Sorry, my lord. Serial number 14. My lord,
Yes.
last occasion I had argued this matter before your lordship, but certain regarding pay scale, my lord, various dates have to be prepared. A synopsis has been prepared, my lord. And I am also out of station today. Kindly have it day after tomorrow. I will come and argue, my lord.
With the request of counsel for the petitioner, re-notify her.
My Lord, serial number 8.
So also 30, my lord. I'm sorry, my lord. So also 30 because I am out of station. Serial number
No,
30.
We will give accordingly. Just give a convenience.
Yes, ma'am.
27-9, sir. Sir,
My lord,
27.
serial number 8, my lord.
Sir, orders.
That's all, all the list.
Serial number 1. To Jayaprakash Reddy.
Grant me 2 weeks time for compliance.
Kindly direct him to serve the copies at least, my lord. It's a,
I'll survey copy. I have no objection.
Shows the file.
it's a order passed by the Debt Recovery Tribunal and SCA, my lord. And directed him to go approach DRAT.
Is petition maintainable?
Now there are two reasons. See, when the repetition filed, there is an interim order granted by this court restraining the secured creditor issuing a sale certificate. Despite this, in violation of interim order, granted the issued a
We're
sale
just
certificate.
asking, what is the order challenged here?
See,
What is
first
the-
of auction notice was challenged before the DRT under section 17. That was rejected. At the time of filing writ petition, DRAT Chennai was vacant. Therefore, I filed writ.
Now you can go there, it's there now, DRAT.
Now, in the meanwhile, after granting an interim order, they issued a sale certificate. So far, sale certificate is concerned, the DRAT Chennai has no jurisdiction. Only, no, sale certificate to be challenged under section 17 before the DRT.
That's right, so challenge it, but how is this petition maintainable?
No, I'll convince your lordship, kindly
You
see.
tell us now.
See, your
Why
lordship,
will-
kindly see, the auction purchaser
We are not saying anything. You have a remedy, either you go to DRT or DRAT.
no, so far sale certificate is concerned, DRT.
Go there.
Please let there be an order. So far, the auction, order passed by the DRT, that is a sale notice before DRT Chennai.
Go there. You appear for whom?
Bank money. First,
You appear for the bank.
bank.
Now, who are 2 and 3? 2, 3, 5, 6.
Whether he has made the auction purchaser party, I don't know, because he has not served any copy. Man.
Today, the petition per se is not
Your lordship-
maintainable.
Your lordship, kindly see, sale certificate issued, the auction purchaser very same day conveyed the property by way of gift deed to his wife. There is a fraud played by the auction.
Are you precluded from taking these grounds before the DRT? You are not.
No, they have not disclosed anything before the DRT for having auctioned the property, and also the earnest money deposited by the auction purchase after the period was over. I will convince your lordship, I will kindly.
You see your prayers. What are the prayers in the report? What is this? And what does the learned judge holds?
The learned judge held that there is an alternate remedy.
That's right. He's right.
No, your lordship, kindly say that that's something. So far, sale certificate issued by the bank is concerned, DRAT Chennai has no jurisdiction.
Where DRT has,
Yes,
go there.
please,
That's a learner single judge holds. So we will record your statement. You will seek appropriate remedy.
please, I'll file a rebel.
Learner counsel for the,
He challenged the sale certificate initial stage and after sale of the property.
whatever, that's on merit.
No, yes, he now challenged the order passed by the DRT. He has to go to DRAT, not DRT.
After the learned single judge has dismissed the petition saying that remedy, you avail the remedy.
Yeah.
There are any further developments which have taken place?
Yes,
No, no.
I filed an application for
My lord.
impleading application.
At the time of filing of securitization appeal before the DRT, the property was sold. That was on 30th to 12,
You are not understanding. What was challenged before the learned judge, single judge,
They challenged the order of the DRT.
DRT?
Yeah.
Okay. Thereafter, learned single judge said ki there is an alternative remedy.
Yes.
After that, anything transpired, anything
no.
happened?
No,
Please,
That's what we are saying.
your lordship,
We
kindly
are
see,
recording his submission that he wants to seek remedy in accordance with law.
there
That's
are
all.
two things, your lordship, kindly see.
my
See,
submission
when the
is-
writ petition was pending, they issued in violation of interim order, issued a sale certificate. Thereafter, the auction purchase transferred by a gift deed to his wife. I can't go to different court for different reliefs. So far, gift deed is concerned, DRT has no jurisdiction. The very same day he transferred.
Tell us one thing, does this court has jurisdiction?
This court has jurisdiction. I will make out a case, your lordship.
No, please. We are today, now tell us this thing, after the single judge has dismissed the petition saying that you have a remedy, any further developments have taken place?
Yes, see, when the petition was pending, the sale certificate issued, I filed an application for implementing the auction purchase as well as the other owners. Without considering my IEA, the
He's still right, you will impede them before those authority concerned. Impede everyone. Today, what we have before is learned judge saying that you have a remedy. That's all we have.
no, I totally agree, but whole concern is sale certification, the remedy be available under section 17 before DRT.
Go there, whatever you feel, we say nothing. We say nothing. It is for you to work out. And just say this, learner counsel for the appellant seeks to withdraw the petition to enable the appellant seek such remedy as available in law. We say nothing on this. Okay,
And also section 14 of the Limitation Act may be recorded.
that you will take it. We say nothing. Say nothing on this. You are going there, go there. Thank you. Dismiss as withdrawn. The appeal.
Liberty
Next.
is given to the,
We are recording your statement. You are here. You will there, wherever you want to go, you will go it, and you will seek the benefit of 14.
please.
Thank you.
Serial number 2,
Next.
serial number 2,
I appear for the appellant, my lord. But
Yes.
matters at serial number 2 and serial number 7 arise from the same order, my lord, of the learned single judge. Lord, so far as serial number 2 is concerned, may I request, my lord, 1 day's time, my lord, to comply with the office objections.
What about the other connected
But-
matter?
My lordship, in serial number 7, I appear for respondent number 3 and 4. My lord, in the other matter, I have written one submission, my lord,
There are office objections there also.
one office objection, my lord.
We clear those.
But I've written a council submission insofar as that other matter is concerned. I'm seeking dispensation of the production of the entire records, my lord. The reason is, my lord, my whole contention that this appellant is a formal party before the learned single judge. And I'm not relying upon any of the records before the learned single judge.
We want everything record must be here, whatever was there before the learner single judge. We don't know which
Yes.
record shall be
Yes.
relied upon.
Indeed. My lord, yes, my lord. Those records, my lord, have been produced at the writ appeal at serial number 2, my lord.
The item number 7,
Yes, my lord.
you have produced.
It's at serial number 2, my lord. It's a batch matter,
Both of them arises from the common order.
common order, my lord.
We'll consider, we don't want to multiply it also.
Yes,
Now we will remove these objections.
yes, my lord. 1 day's time, my lord, I'll come.
Give you time. Counsel for the appellant seeks and is allowed 2 weeks to remove the office objections. Just remove this. In 7 also, you are the same party in 7,
Yes, my lord.
My lord,
Is-
3 and 4.
3 and 4.
Yes,
3 and 4 also. We'll take it up along with the 7. This.
please, my lord.
So this will be the order. Next mail. Just pass. So we'll take it up along with 7.
Please, yes,
Please.
serial number 3,
6 weeks are granted to remove the office objections.
611, serial number 4, Shishankar Reddy,
Same. 4 also.
611,
So same.
711,
6.
serial number 6,
That the Kannada, English translation of the Kannada document be filed within 6 weeks.
711,
Now 7.
7, serial number 7,
Here for the appellate.
7 also separately same order. How much time? 2 weeks.
Please, my lord. Lord,
7 also.
in serial number 7, I've complied, my lord, with all the office
We
objections.
have complied with?
Yes, my lord.
Okay.
This
When
one-
counsel for the appellant submits that the office objections have been clear, if that be so, comma, the registry shall verify the same. We notify on the same day. Both of them.
30th September,
I'm grateful, my lord.
Please.
very detailed, sir, serial number 2 and 7. Serial number 8, Vikiran,
Let
No,
notice be issued to the respondent 4 and 5.
Furnish in the address of R4 and R5. We have to furnish the address of R4 and R5, my lord. Please,
For the appellant counsel for the appellant furnishing the fresh address
Yes,
of which respondent
R4 and R5.
4 and 5, sir.
are 4 and 5. We notify.
811,
Just say returnable.
811,
Much okay.
Serial number 9. She says Shri Rao.
Pass over.
10. Serial number 10, Shri Prashant HS. Also. 11, Shri Dalbhai Venkatesh.
By order dated 10th January 2024, Lordships have held that appeal is maintainable and my lords by subsequent order directed to be posted for final hearing. Right.
Directed.
To be posted for final hearing by order dated 14/2/2024. By 10th January, your lordships held that appeal is maintainable.
Yes, who appears? You appears?
Respondent, two.
Yeah, one state. You are ready to hear for arguments?
I'm ready.
Some date, my lords, your lordship. Maintainability is already held to be maintainable on 10th of January 2024. And on 9/2, my lords, of course, it can.
22.
The parties to file their written submissions.
Good.
Along with the judgment, they want to rely on.
2210.
Good.
Serial number 12, Srimati Shweta Anand. 12.
Appear for the petition.
Yes, ma'am.
I'm ready with the matter because on the last occasion, the complaints was done. With regard to there is an office objections that I have not filed the complaints memo. And your lordship has directed my colleague to go ahead. Yes,
You are ready for argument?
yes, ma'am.
13, Shri Kulkarni.
Before the respondents.
Mr. Kulkarni wants a parcel.
Pass.
Much.
14 adjourned. 15, Srimati Nalini Venkatesh.
I appear for the petitioners, my lord.
The review petition.
Please, my lords.
You are seeking review of which order?
Of the order dated 10/2/22, my lords.
Right.
Now, the facts in brief, if I may be permitted to submit.
This is only regarding that Mr. Bhushan on that statement.
That's all, my lords.
Please,
Now
madam.
tell us what is the position today as far as Government Union of India is concerned?
Absolutely nothing, Lord. We don't have,
Remains the same?
Lord, on that day, what happened was, my learned friend was arguing the matter. She referred a judgment. The court could not hear it. So I just told that the judgment, my submission is noted down, my lord, that,
It says that regulations of 2017 will be applicable.
please.
No, my lords, what has happened is, my
In
lords.
fact, it was their
the-
statement that those regulations.
Because,
No, just 1 minute.
please,
Are
my
you-
lords.
Insofar as the submission is concerned, do you say that these regulations are not applicable?
No, the only thing is that it will not have any effect because, my lord, the exams were conducted on an all India basis.
You are right.
My
it may
lords.
Not have any effect.
No,
But
That's
insofar
the
as
only, if that is made, my lords, because what happened is, based on that submission, I may submit, my lords, that the Union of India is a pro forma party. No relief is sought against it. And I made the Union of India a party only because in the OA, the respondents 2 and 3 had made the Union of India a party.
You are for the RPFC.
Please, my lords.
Now, we just want to know if that statement, Mr. Bhushan, can we take it that that statement must not be read
Please.
insofar as Union of India is concerned?
Please, my lord.
That's all, my lords.
Whatever is the effect,
Please.
what do you say?
May I just, without reference to any papers, may I just explain what the controversy is? Its notification was issued, my lords, calling for promotions by way of limited departmental competitive examination. My lords, in the notification, they said that the vacancy will be calculated year-wise, which was not done. We approached the CAT. CAT said, do it year-wise vacancies, accordingly do it. My lords, the Provident Fund Department,
Yes,
for whenever the vacancy arose, year-wise vacancy was what was contemplated.
before 17 or after 17?
Before 17, there were a lot of vacancies. The notification calling for limited departmental competitive examination said that the vacancies will be classified year-wise on the basis of which the vacancy arose. That was the notification. We approached CAT. CAT said, do it year-wise as per year-wise vacancy. Provident Fund came before your lordships and said, the regulations of 2017 does not contemplate year-wise vacancies. Therefore, we will not do it. I filed my reply and said, but they are proceeding on the basis of the earlier regulations. Now, in their rejoinder, they said, the eligibility criteria will be as per the rules which were available when the vacancy arose. The examination will be conducted as per the 2017 regulations. Promotions will be given as per the 2019 rules. I said that cannot be the contention because you will have to follow one rules, either when the vacancy arose or as per the 2017. That is all my case is.
Does the tribunal say anything on these things, what you are saying?
Tribunal only said, please do it year-wise.
So you have not come in appeal?
No, my lord.
So do it, that's the only limited. The question that which regulations will hold the field or which will govern this LDC is an inconsequential or not, is a non-issue.
No, my lord. They have now made it an issue by saying that we will fill up the vacancies in 2017 as per the procedure of 2000. Yes.
Once the tribunal says you will do it year-wise, we leave it at that for them to work out. We say nothing. Mind it.
Yes.
That's not a cause of action. Today they have to actually carry out the LDC examination based on the tribunal's order. In what manner they would do it is for them. Does the tribunal say you will do it under 17 or 19 or pre-17?
No,
say so.
No, but they are saying that we will not do it as per the year-wise vacancies.
Where do they say so?
In their writ petition. And that is exactly what they have said.
Tell us one thing.
No, my lords,
You will hear us.
yes,
You will
I'm
hear
sorry.
us. What was the occasion for you to say so? When the tribunal say you fill up the year-wise vacancies?
We challenge that, and that has been set aside by this honorable court. Altogether, we had filed 9 writ petitions, my lord, challenging the order of the OA, that is CAT. 7 of them were allowed. These 2 were pending because notice had not yet been served on the respondents. Subsequently, when it came up on
Does the tribunal say you will do it under 17, pre-17, post-17 or
that,
19?
that was not their case at all, my lords.
Then why did that petition?
No, what has happened is because of inadvertently the Central Government Standing Council that was taken on record, that has caused confusion all over India.
Now we will, so far that is concerned, we can take it. Insofar as the submission is concerned, they being a performer party.
Exactly, my lords.
Posed to me, my lord, by the.
We will say so that it must not be construed as a statement given by the Council for Union of India. We will say
It will not have.
whatever is the position, you will work it out.
And my lords, I'm sorry, my lords, the results were announced in 22 as per the order of this honorable court in the 7 writ petitions. And subsequently, the subsequent order in 2 writ petitions, they just followed the earlier order. That's all, my lords.
And there is no
That's
objection
all.
for review.
Today, the review petition is on a limited aspect
Oh, exactly, my
on
lords.
that submission, that's all.
That's all.
So we will say, so we'll take Mr. Bhushan's submission,
Please, my lords.
that it must not be construed as a statement given by him. Now tell us one thing, now can we say that no such state submission was made?
The reason the submission was made, even though I'm a performer party, my lord, when the court asked me, I told it should be read para 2 of the writ petition. Para 2 of the writ petition, my lord, there was a already decided matter that I told my lord, this judgment holds good for this matter also. Of course, my lord, the order was passed.
I don't think it makes any difference because their statement is that regulations. And now
We will say so only, Mr. Bhushan said this statement must not be construed as a statement on behalf of Union of India being a performer party.
Please,
yes.
That's all.
That's all, my lords.
Now the difficulty is this, my lords. Now what has happened is, since there was a direction to follow the 2017 regulations, they did not follow it. Now, my lords, we have filed contempt petition as well as challenging the promotion. Now, their case is, if this sentence of 2017 is deleted, then the promotions given on the basis of eligibility of some other rules is correct.
Mr. Prithvish, tell
Yes,
me,
ma'am. Yes, I understand.
is that an issue here?
That, in fact, in the writ petition, they say that, Manoj.
That was not
That-
the issue in the writ petition also.
What is challenged in the writ petition is the order of the tribunal.
Yes.
Saying that you do it year-wise,
Yes,
and that's the position of law. It has to be year-wise. We said, very well, let's forget it, don't do. So, that's the only issue.
yes.
Insofar as this submission, we will clarify, let them take it. If you are agreed by any action which they intend to take it in the manner which you are not saying, you will be within your rights.
Well, that's just one submission. The latest development is, my lords, that the head office of the EPFO on 28/11/23 has issued a calendar for limited departmental competitive exams, whereas the earlier ones were held in 19. So now subsequently another notification and probationary exams in the EPFO. Notice dated 7/6/24 for conducting the said exams for promotion to the post of section supervisor for the vacancy position in the cadre of section supervisors.
Just see your prayer in the review petition.
No, that is exactly, my lords.
I'm not going.
I am
into-
satisfied, my lords, with only that.
This review
I just
petition-
wanted to bring the latest position.
This review petition has been filed by the petitioner, Central Provident Fund Commissioner and others. In review of order dated 10/2/2022. On a limited aspect, wherein the court had recorded the submission said to have been made on behalf of the respondent number 1. So Mr. Shanti Bhushan, Deputy Solicitor General of India, submits that the said submission be not construed to have been made. Said submission may not be construed to have been made on behalf of respondent number 1, as respondent number 1 was only a performer party. Was only a performer party. That's enough.
That's all.
It's enough, Mr. Prithvish and Mr. Bhushan.
Please, Manoj, please,
Very-
respondent number 2, Manoj.
Mr.
That's respondent number 2, Union of India.
Respondent number 2, Union of India.
Yes.
Clarify that.
And it should not come in the way of
He
the
said-
results,
He said
No, no.
nothing.
because already in trade, that's already over.
He said nothing. That's all. This is the limited aspect is the submission.
That's all,
We have
my
taken
lords.
Mr. Bhushan's submission.
Yes.
Simple.
That's all, my lords.
So in view of the submission made, the learner counsel for the petitioner, Central Provident Fund Commission says, the review petition be disposed of. It is ordered accordingly.
Please.
Thank you.
Much obliged.
The CPFO also. No, Officer of the court, I mean, some submissions they should.
Thank you.
Please, Lord, the CPFO, the Central Provident Fund, also, my lord, they can't say that Union of India is a performer party, because when the court asked me, I'm an officer of the court. I mean, my lord, in this matter, my lord, a long mail of 10 mails have been written. Why did the Union of India make a submission? I just clarified what my learned friend told. That apart, I did not do it.
You know what? Every counsel is an officer of the court.
Please.
Let's be very clear on that. Fine, we leave it at that. We dispose.
Please.
Thank you.
Much obliged.
Great.
16, Shri Mali Patil.
Lords, I appear for the appellant.
I appear for the first response.
Lords, I pray for a week's time, my lords. We haven't received the instructions yet, my lords, on the issue. A week's time may kindly be granted, my lords.
Yes.
My lord, on the last occasion, Lord, the contention which was raised by the appellant was that, my lord, a counsel was not given wakalat. Then, my lord, I have given a certified copy of the wakalat.
So that we have, in fact, we have said, but in any case, there is a wakalat on behalf of
My lord,
the.
I am the person who have filed the wakalat, my lord. That is Sudhakar. On behalf of Sudhakar, I have filed the wakalat. We have sent an email, my lord. We were on.
Who appeared for this institute?
In the writ petition, my lord, we appeared, my lord. It was ILPM consultancy. It was given.
See, we have, on the last date, we noted the submission.
Please.
That it has been given by the chief
Please.
administrative.
Yes, it was given. And we have.
You appear for whom?
For the same institute.
Sure. Now, who appears?
My lords, I appear for the institution now, my lords.
You are,
My lords, PS Mali Patil, my lords, the council,
Okay.
on behalf of PS Mali, Abhishek Mali Patil, my lords.
so B. Sudhakar is not appearing.
My lords, he's not on the panel of the, my lords, the Bangalore Medical College.
So you
My lords,
are-
there are some communications, my lords, sent, my lords, to the council to appear. It appears, my lords, it was not to this council. My lords, we'll place that, my lords, we'll just ask for, we have asked for those.
going to, it's not going to that. So better would be, you are filing your wakalat.
We have already filed, my lords, in the appeal, we have filed, my lords. The appeal is filed by us properly before the writ petition, my lords.
No, even that wakalat was filed in the appeal only.
No, madam, it was in the writ petition.
In the writ petition.
For the writ-
In the writ petition, we have filed the wakalat.
You are,
My lord, I am appearing on behalf of Sudhakar. We have filed the wakalat.
but now he says he will appear. Let-
Please, my lord,
Let him
that is
file
not the
wakalat.
issue, my lord. That is not the issue. Issue was they have not given the wakalat to us to appear in the writ petition. That's what they are telling. But it was given.
Let's not go.
Please,
into
ma'am,
it.
please.
Where are we going?
A week's time, may kindly be.
So the so and so appears for the appellant and states that henceforth he shall be appearing for the appellant institute. So he also states that wakalat has been filed on behalf of the research institute. At his request, re-notify. Are you not ready?
Well, it's a week's time.
No, it's a small issue.
It's just a week. I'm awaiting instructions, my lords. That's all.
Re-notify, at his request, re-notify.
My lord, may I make one submission? Dispense with that Sudhakar, sir.
Mr. So-and-so who appears for Mr. B. Sudhakar submits that Mr. B. Sudhakar be
Maybe
dispensed, it may be recommended that Mr. B. Sudhakar shall not be appearing for the research institute henceforth. Please, it's ordered according. Is your name, just give your
Prashant
name.
B.R.
Mr. Prashant B.R., who appears for Mr. B. Sudhakar. Just say that. Next.
55-9, sir. Seventeen adjourned, 18. Serial number 18.
Respondent 1 and 2.
I appear for appellant in this case. Kindly pause.
You are ready for arguments?
Kindly pause.
Pause.
Let it be called next week, Malad, because I'm not keeping well, Malad. No, I argue it, but fast forward means, Malad, let it be called next week.
So we'll come back fast.
No, let it next week.
The request of council, though a passover has been sought by the council appearing for
Respondent.
which
Three,
respondent?
respondent number 3.
Three, the appellant, the council for the appellant seeks an adjournment.
Next week it's.
We will see,
Yes.
on the ground that on Passover he shall have difficulty. Just give away a convenient date.
22-10.
Next,
19 adjourned, 20, Shri Akash. Serial number 20.
it's Mr. Ravi Shankar.
Lords, a very short question, my lords. Probably the institution requires to answer this. Lords, two of the doctors were appointed to the cadre of assistant professor by virtue of the proceedings dated 13/9/2007. Appointment orders were issued on 6/10/2007 by.
Just 1 minute, who appears for the institute? For the.
Yes, they have to make a statement.
Jagdish
Appear-
Bhai.
The state must be appearing.
It's an autonomous institute, my lord, so.
Who has conducted the direct recruitment at that time?
Lords, the institute,
The institute.
yes.
Who appears for the institute? Yeah, ultimately they have to show the proceedings of that.
That's all.
That's all.
That's the only point. At page 209, I've produced the proceedings, but what copies they gave me is incomplete. The index, which I have now filed it along with the memo, says the proceedings is from page number 17 to 20.
See, we wanted to see.
That's all.
We wanted to see those proceedings.
That's all. So that's the point.
The appointment, we see both were appointed, I think, pursuant to the same advertisement,
There was no advertisement.
or there was no advertisement.
Yes.
There was no advertisement. Para 17 of the order, Leonard Single Judge notices the statement made by the institute. What it says is, the institute was established in the year 2006. There was no academic staff available in the institute. Therefore, whoever wrote to the institute seeking appointment, they were, the proceedings were conducted by
Minister who? Both were considered in the same.
Proceedings.
Proceedings.
Yes.
No proceedings have been drawn up. Oh, they have no proceedings? There is no proceedings drawn up.
Page
Then
209, my lords.
even selection committee, the selection committee supposed to be constituted under the bylaws did not consider. Chairman of the institute, who is the minister, and director of the institute, they. You were shown senior to her.
Yes.
No, but he was, yes, he was shown senior to her. I was shown senior to him. But she was promoted to the post. Yes, my lords, and kindly, my lords, one aspect, 2012, the seniority list was published. He does not question it, even though I was shown senior. Then he is promoted ahead of me, applying the principle of merit cum seniority. But the rule says that it is seniority cum merit. I question the promotion granted to him. 10 days thereafter, he was in caveat after receiving notice. Thereafter, he questions the seniority list of 2012 after a lapse of 3 years, 2 months. Therefore, my lord, I raised a contention. Kirti. You appear for Dr. Sudhakar. I appear
for Kirti.
Sridhar. You appear for Dr. Sudhakar, you appear for Dr. Kirti. These are the two
Yes.
persons, no? Yes.
Lords, may kindly have a look at page 208 for a moment, Lords.
But are we sure that there are no proceedings?
Lords, kindly have a look at page 208. Page 208, Lords.
Page 208. Yavudu? 208 is a
I'll mention. Page
promotion
208.
proceedings, not the direct recruitment proceedings.
Lords, page 208.
Each appeal, Mr. Ravi.
Lords, I'm sorry, my lords. This is in 224 of 23.
That is pertaining to promotion to the cadre of associate professor. You said 20?
208, my lords. First, I'll just take your lords to page 208. Lordship gets it, my lords. Lords, bottom of the page, the following applications are received for the post of assistant professor in the Department of Pediatrics. Lords, there are 3 applicants. 2 are selected. Now the next page, page 209. These are the proceedings dated 13/9/2007. Lords, if out of 3 applicants, 2 are selected, there should have been some basis on which they would have excluded one of them. Lords, this page number 17 is very, very crucial. Lords will kindly see that page number 17 is at the bottom of the page.
These are initial appointments.
Yes, this is the initial appointment. There are 3 persons who are applicants. Then page number 17. Lords may now kindly take the memo which is filed on 3rd of August 2024.
17, no?
3rd August 24. Just about 3 days back, because we could get this index under the Right to Information Act.
This was part of the pleadings.
30th, I'm sorry, 30th August. Memo dated 30th of August. In that, there is an index, Lords, of these proceedings. 4E, almost 4 entries from the bottom of the page.
Yes.
Creation of 1 post of assistant professor in pediatrics department and 2 posts in assistant professors in ENT department and 1 of the associate professors in the Department of OBG, 17 to 20. Notice this 18 and 19 is something which we are not in a position to get from our efforts. That's the reason why I said, if there were 3 applicants and if they have selected 2 applicants, there should have been a methodology by virtue of which they have excluded 1. That is a statement which requires to be made by the institute. What is the methodology? Because the principle is, if simultaneously the appointment orders are issued, then if there is no rule to determine the seniority, then the appointment will be based on, if there are multiple applicants, will be based on the merit of the qualifying examination. Notice I have the highest merit in the qualifying examination as on the date.
How do we get that?
That page number 60 and page number 116.
No,
Page 60, if your lords were to see, that takes.
If you are saying that you were more meritorious.
Yes, page 60, my lords.
Some basis.
That's the reason why I said page 60.
Yeah.
This is the comparative table. This is, lords, what we are concerned with the qualifying is the second column. Marks obtained in MD. Sridhar is 350 as against the marks obtained by me as 396.
So this was the criteria evolved by them.
Yes,
No.
this is, notes, now,
There
if
is
there
no
are
trade
two
test
applications, inter se merit will have to be decided only on the basis of the merit in the qualifying examination or the inter se merit in the qualifying examination. Now, inter se merit, if it is considered, I score more than that. But nonetheless, the learned single judge says that there is nothing to indicate whether inter se merit was considered or not. Therefore, the learned single judge proceeds on the basis that in such circumstances, the service jurisprudence contemplates the age as the criteria. Since Sridhar is more aged as on that date than Kirti, therefore Sridhar's seniority is to be upheld. That is how the single judges dealt with it. But now 17 to 20 minutes, that's the reason why I said 17 is produced, 18 and 19. If one candidate is excluded, then they will have to say on what basis they excluded that candidate. Some methodology would have been adopted to exclude one candidate.
What is your stand with regard to the selection initially happened? What is the basis for you?
Our contention before the learned single judge was, actually, the institution was started in 2006. Then the students were admitted, so no teaching staff. Like walk-in interview, the publication was made. Then 3 candidates applied. Then out of 3, 2 were absorbed as assistant professors.
No, but tell us one thing. For what reason you excluded the third person?
That's it.
What was the basis?
That even the submission was made before the learned single judge also, that no proceedings were made.
I'm in a position to demonstrate. There are proceedings. If they want to withhold,
Whose stand is this at 60, Mr. Shavishankar?
page 60, my lords.
That's
This
right,
is
yes.
my stand. Lords, this is what is borne out in the marks card which are produced at page 95 and page 117.
What you are saying is, since you have secured more marks,
Yes.
the basis must be that.
Lords, because bylaw number 17 says, bylaw 17, lords, what the learned single judge says is, no doubt the bylaw stipulates that merit should be the criteria for the purpose of determining the seniority when both have entered into the cadre simultaneously. Now, the learned single judge says, since at the initial appointment, inter se merit was not considered, so this rule is not applicable. Rule 17 he dispenses and says the general principle that age should be the criteria for determining the seniority is applied. That's how the learned single judge. I'm in a position to demonstrate proceedings are drawn. Now, page 18 and 19 they will have to produce.
But he says there are no proceedings.
Lords, I produce the index. That whole book is there.
Let's see that.
Submission, even the objections are not filed before the learned. From the
Institution has not filed the objections.
Will you file objections?
Please, in this.
File your objections, but you must also look into this. What is being shown by Mr. Shavishankar is, see, there is a memo, Mr. Ragopal, you have this memo.
I have that memo, man.
Now, just see this memo.
In fact, that was part of the writ petition.
No. It was not.
Now, he says that the creation of post, 2 post assistant, and he said there must be some basis for them to say so. This index.
18 and 19.
18 and 19, those are missing.
When I went through the order sheet in the writ petition, my lords, they had not filed statement of objections. So the director was summoned to before the learned single judge. And the statement he made is, sense of it is taken at paragraph 17 of the order of learned single. At page 26.
Yes, 17.
In the case, that is, my lords, that is running page 45. In the case and petitioner and respondent 3 are not recruited or appointed in pursuance of invitation or by calling applications through recruitment notification.
Yes, 1 minute, Mr.
Please put again.
Yes.
The respondent institute was established in the year 2006 and the institute was in need of teaching staff. In the such circumstance, the institute considered the application submitted by individual qualified candidates for appointment to respective posts and appointed qualified persons as teaching staff. In respect of petitioner respondent, the individual applications dated 20th August and 17th August were considered by the governing council consisting of director and concerned physical education minister under proceedings dated 13/9, and both of them were appointed by individual appointment orders dated 6/10/2007, the second date is wrong, my lord, it is 6, it is also 6/10. The appointment of the applicant and respondent is not by following the procedure prescribed in the
That's-
bylaw number 10 or 11 of 2005 laws. By appointment of the petitioner and respondent is not by selection committee constituted by the institute or by recruitment notification. The selection and appointment of petitioner is not under a common proceedings or under a common recruitment notification.
Now, this is important. What is said, the selection appointment of petitioner is not under a common proceeding.
Which is not correct.
That is what, that is what the statement, in fact, I went through the order sheet. He was summoned. What statement he made is not recorded.
But the only thing is, but though the appointment letters were issued on the same day.
They were
It's
issued
only-
on the same day.
The joining was different.
Joining was,
Joining were different.
Date?
But you file your, let them file their.
Let them, they have to make a statement, my lords.
We want that stand must come on record.
Yes.
File yourself. You just say this, the council appearing for the Mandya Institute of Science.
medical sciences,
Pardon?
Mandya Institute of Medical Sciences.
Medical Sciences, that is respondent number 2. In both the appeals. Let's say that.
WA.
Let's check it. In both the appeals, states that since no objections were filed before the learned single judge, he intends to file objections to this writ appeal. Noting the submission and the learner senior counsels appearing for the appellant and the respondent number 3, has no objection in that regard. The objections we filed, how much time? 4 weeks. 4 weeks. Rejoinder we filed within 2 weeks thereafter. We notify after 6 weeks. So while filing the objection, the learner counsel appearing for the institute shall also consider the stand taken by the director. Stand taken by the director before the learner single judge.
Yes, ma'am.
That's right. Let him look into all this also and then file a reply. Now though you didn't get the seniority, but you got promotion.
Yes, that is the thing. ma'am.
It says based on this, the Sridhar is given the seniority. Now, it is only one post of person which is qualified with due for promotion. Let them not make a promotion in the next year again.
But you are only the 2 contenders.
Both of us are now in the cadre of associate professor.
Pardon?
Both of us are in the cadre of associate professor. Both of us are eligible for promotion.
Very well.
But now, my lords,
What do you say?
No, because of the pendency of these proceedings, we could not do anything. Because
that-
ultimately we are bound by the.
Very well, then till such time anyone is to say, you say that no promotion be made. But who would act as the head of the department?
head of the department is by rotation, man.
No, no. That is the overall administrative
For this department.
for this department.
Yes, ma'am.
Then no effective. No
Now, my
prejudice.
lords, in
Then
2000,
don't make any promotion. We say that the learner counsel for the senior counsels appearing for the appellant and respondent numbers 3 states. Though a post of professor has become vacant, the institute may not make any promotion to that post. The learner counsel for the institute submits during the pendency of these appeals, no promotion to the post of professor shall be made. That's it.
but only one thing, whether he succeeds or I succeed is not relevant. The point is this, ma'am. To be eligible to apply for the post of director in any institute, candidate should have worked as professor for 10 years. That may be borne in notice. Ultimately, whatever.
That we are recording your submission and your submission, Mr. Rajgopal and Mr. Ravi.
Now, what is required is, my lords, at the time of final disposal of the writ appeal, that equities may have to be worked out, because in the fight between these 2 persons, both professors of pediatrics should not become ineligible.
See, that, to be very frank, I think whatever submission you have made is the right submission. Suppose for a moment. Let's assume for a moment you say, कि, okay, one of the person must be considered for promotion and be promoted as professor. The person who gets promoted, for him, the eligibility starts running. from the day
That is
you
why,
get
not,
promoted.
therefore, that is why.
Not against this other person.
Therefore, my
So
lords,
balance the equities is whatever. is the
balancing
status quo.
equities has to be done at the final disposal. Say
That
because
we will consider.
that is the only thing, my lords,
Yeah,
because.
that's well taken. We look into it, just remind us.
Great,
Just remind us.
grateful, my lords.
Thank you.
2410,
24.
the 2410.
Great.
So number 21,
Yes. Pardon? Get through? We are ready to hear you. We'll just pass over, we'll come back.
also. 22 urgent, 23 Shishu Kumar. 23,
Dismissed objection. Yes, sir. Page 28, sir. 29, sir. Yes. But I have. Oh, sir. You're ready? We can hear you? Yes. We'll just pass over. Yes, sir. No further than drop the proceedings charges. Serial number 21, to seek instructions. We'll see, we'll come back. Yes, we'll come back. Pass over.
20,
We'll just see it, Mr. Council. Come 24.
24 Shebchik Chandra Gowda.
Here, notice has been issued.
Please, ma'am, please.
What is the issue, Mr. Prabhu?
Lords, the issue is they're asking for a non-executive post, my lords.
Sir?
Pay, my lords, pay of, basic pay of non-executive post, my lords, with effect from 8/1/2016. That is from the date of promotion.
We'll have it along with that.
Please, ma'am.
What is the petition number? But you have to, that arises from the same order. Is there-
Different orders, my lords. There were 8 to 10 matters decided, my lords.
is there
Similar
any date
matter.
there? Is there any date there? Is
No.
there any date of hearing? Do you have? Just check up. We'll pass over, get the date, give it to the court officer.
And notice has to be ordered to
notice.
other respondents, my lords. I have here only for respondent number 1, my lords. They are the contesting respondents, my lords. 2 to 4 are the contesting.
Yes, sir. We have been informed that a connected writ petition being, what is the number? 9102 of 2024, arising from the same impugned order. The court has issued notice to the respondents. Mr. Pramod, appearing for the Union of India, concurs with the submission made by the learned counsel for the petitioner. If that be so, issue notice. But you have to only tell the date so that we can fix it on the same day. The date is not given. So we will adjourn it, file a memo in that. Just say the connected petition. And accordingly, issue notice to the respondent, Mr. Pramod, accept notice for one. Let notice be issued to the, you appear for KIO CL also?
No, my lords, they have got a separate.
Let notice be issued to the other respondents returnable on.
611.
Much.
What happened to that Murali NS? On which reliance has been placed by the tribunal and disposed of?
My lords, even that they have challenged, my lords, now. Even that they have challenged before this on court.
That's a different writ petition.
A different petition, lords.
So we may have to list it along with that.
Please, please.
What is that writ petition about?
I have not.
That's right. That must be the counsel who appeared for Murali and
Please.
because that judgment is in against the petitioner.
Please, my lords.
We don't know, you work it out, you just see, get your instructions.
Please.
We know, just it's all. Next.
25. Ashok Kumar.
My lords, for the respondent number 1 and 2, my lords, we wish to file our objections. My lords, may kindly grant us time.
You appear for whom?
For respondent number 1 and 2, my lords, they are the,
Petitioner there before the learned single judge.
Please, my lords.
Before the DRAT.
No, my lords, we were the petitioners before the learned single judge.
No. This is a
My lords,
petition.
in the WP.
In DRAT.
Please, my lords, there's also a WP in this matter, and that orders on which we wish to produce before this court. Your Honor,
We can only say this, Mr. Kasturi, all of you will file your written submission.
grateful, my lords.
No pleadings. You have filed. You were the appellant before the DRAT.
DRAT.
They were the appellant. So and so appears for respondent number 1 and 2.
We appear for respondent number 3 bank.
States that he intends to file written submissions. Who appears for the other respondents? Notice not there.
Respondent number 3, I appear, my lord.
My lords, for respondent, there are 3 respondents, my lord. 1 and 2, I appear.
You are the contesting respondent.
All three of us are contesting respondents.
Other respondents. Acha, there was a submission made on the last date.
Grateful, my lord.
Senior counsel for the petitioner instruction submit the petitioner shall not press the petition qua respondents 4 to 11. So no need. So 1, 2, 3, all of you 3, you file your submissions.
Please.
Just say 1, 2, and 3. It says that they shall also file written submission. If the same be filed within 4 weeks,
Grateful, my lord.
we notify the petition for hearing on.
711.
Next. Interim order, if any, to continue.
26.
Correct.
98. But tell us, Mr. If there are vacancies in 98, you grant them temporary status also, you continue with the same status without any regularization. Where will they go? If you are saying so, we'll record it. From which date the post became vacant or available? You say so. Is it your case that 1998 there was no post? With that nomenclature? what is the equivalent post where the people are involved in horticulture? That's post seventh pay commission. That's post seventh pay commission.
Yes.
But we are talking of a position before seventh pay, 98.
Prior to that, there was no post. We did not have any post for Mali or Karnataka.
So there would be, Mr. Khan. Where does the petition say there is no post? Then we may have to have two information. See, Mali in a way is a specialized work. Person should have basic knowledge of horticulture. When you appointed any person on this equivalent like Mali or a gardener, was he required to have any specialized qualification?
No, nothing. We are not have regulation. We is only fourth standard, fourth grade is what is.
Okay. But tell us one thing, did you not appointed any person with this nomenclature at all?
No.
Then what is the purpose of granting them the temporary status?
Because the direction of the tribunal.
See,
We did not want to pay at that point of time. There was a scheme available, they granted it temporary status.
so if that temporary status having been granted, now now the Union of India take a plea that there is no post?
For that, temporary status, post is not necessary.
You're right. But temporary status is a step towards regularization. That's the scheme.
No, we create 121 scheme, where I granted in the temporary status. Please have a look at the four such laws. Such conferment of temporary status would be without conference, availability of regular.
We are with you on that. But that's a step before regularization. But now what is? We will issue notice. We will issue notice. Take instructions also, if not 98, which is the date for regularization? Issue notice. Just show us this thing. The gentleman has retired, has attained the age of superannuation. He's continuing. He's still working. But on temporary status only. That's the status. Issue notice.
All benefits that we can do this and use it. The moment beyond the benefit, we need to draw all that.
Issue notice, returnable. One of the submissions of Mr. Kamath Leonard, ASG, is that the tribunal could not have fixed the date of regularization as regularization of the respondent as 17/6/1998. More so when there were no vacancies, when there is no post with the nomenclature Mali. That's right. And the respondent herein was only fourth pass. That's right. In other words, it is a submission. The direction has been given by the tribunal without ascertaining as to whether the respondent fulfills the eligibility conditions, if any, for the post of Mali. Issue notice till the next date of hearing, the operation of the impugned order. We have been just saying also this, we have been informed that the respondent is working as of today with the temporary status. So with that be so, issue notice till the next date of hearing, there shall be stay of the operation of the order dated 11/3/2024 in OA 170/00368/2020. Insofar as direction has been given by the tribunal to regularize the petition respondent with effect from 17/6/1998. Returnable on Just give notice, give returnable date.
7/11. Twenty-seven.
Not, the petition may have become infructuous. Let my,
My lords, I'm appearing for R4 in this matter, my lords.
Yes. Can we say this? Can we say that we'll hear it? If you say it's not in it, file your submissions. Would that? What about you?
not, we have all filed.
What is your ground that it has become infructuous?
Lord, it was for elections from the year 2019 to 2022. Therefore, they are not in office anymore. The persons in respect of whom these proceedings are, the respondents are not office bearers anymore.
Subsequent elections took place.
Subsequent elections took place.
There were various malpractice committed in the course of administration. The BCCI has also non-elected constituted committee is not under the then challenge the Department of Chief Justice of India and for the Department that is measures. The committee is not conducted meetings pan India and was suggested that the very piece not the interpretation is not of the rule of party. The honorable experts, they are the past direction, not the legislative committee is not the formulate the rule, present it not for the honorable, but honorable experts accept that it is not the rule, and thereafter not that much the interactive is going to be done. Yeah, that can be followed, please not see the other rule book. Now, what must say for consideration of honorable experts? There are two aspects. Any person will not continue in office for ends of time without not any clause better than number of talks. Age was not a factor. Politicians could come on stand for election. Criminal also could come and stand for election. But some this aspect not the affects of cases like regulation not gone. The second place is not we bring about much clearer administration. What much better has been put inside into the system is that after every 2 terms, much 3% understanding for election. Compulsorily is not adhere to one cooling off period. So after 2 terms, you can contest for 2 terms. 1 term is a cooling off period. Maximum of 3 terms. Irrespective is not of the office. You may be an office bearer, you may be a committee member. There is an ethics council. What the honorable ethics council? That's a 9 members.
No, those recommendations have been accepted.
Accepted, the rules have been formulated. In this case on hands, in private response, what they would do is, having completed not 9 years in office, not in one way or the other, having not checked office fees, not the continuous period of 6 years, they still hold office, but they contest of this election also. Cooling of period was not adhered. This aspect will not have challenge working on it. So by the time he is not the contested for the election, I was already focused. Matter was not heard greatly. It was by quadrant range of the sound. Total result for all. Now there are after 1 year also, definitely company passed release from part. Thereafter, the law is meant to be from another quadrant. Matter was heard. Because it was result for all. Thereafter, the law is released part. At that point, that also it was not impact. Now we not take contention of the contention. The location we have deleted out. So therefore, this is not impact. I respect the submission. The honorable expert has taken very much change, not to put the affairs of the board of control in India and the state organizations is not on track. If this order again will not come back next year, I will again have to come back. So if my lords have to say, not that the order of the Ombudsman is justified, I don't have a case. If my lords have to hold. The event is not the order of the Ombudsman.
What does the Ombudsman hold?
She not holds that 2000 to 19, 2013 to 19. There were no elections. So it cannot be considered as 2 terms, it has to be considered as 1 term. And the other person is not seen as 3 terms in office. The honorable Ombudsman would hold not that. This person has really been in office as a as an officer, as a managing committee member, not as an office bearer. These aspects will not stay for consideration subsequently, not before the honorable court. And the others of the BCCI is not as directed in the judgment of your 2020. That is what directed the BCCI seconds on the number. There are new regulations in place. Now, clear matters have been put in place. It's not a day beyond 9 years.
Not a day beyond?
9 years. Look at the laws. Not a day beyond 9 years. That is ingrafted, it is not in the constitution of the BCCI. But the original direction was in 2015, the first instance. What has been engrafted clause in the affairs in the rule book of the BCCI, we find a mention clause in the affairs of the state. So that has not been. But the BCCI law has said in this rule book that not a day beyond 9 years. So my humble submission is these two persons, if they will come back again. This is infractual. They will come back again next year.
But tell us one thing, today they are not holding the position. Now this may, your submission is on the premise, they may contest in future.
Unfortunately or unfortunately, they refuse the nomination. They are being contested.
Now tell us one thing, if that situation arises, then you would come back? Today.
Before this court, this petition itself, I waited for 4 more years.
Right, suppose for a moment they don't contest, where is the cause?
They will contest. This is what the ethics court said, is not a concentration of power at the hands of few elements. This is not destroying the game of cricket. And legal charges.
Now the rules are in place now.
They are in place, but they offer some interpretation. Otherwise, that is the problem. Now they will come back again next. Again, I have to come back.
No, but tell us one thing, the interpretation sought to be given by the ombudsman, they get eligibility.
They will get on the basis of the teeth of the ombudsman sort of thing again this next time. They are disqualified.
So what you say is that is the ombudsman's order under challenge?
Yes. And next year we have to launch it under challenge.
How long you would take? 1 hour. See, we'll pass over the matter, 2:30 we have fixed a special date. We will fix a date. Then we will fix it. We have paused it because 2:30 we have kept another matter. And we have passed over also, we'll fix up a date for hearing. Yeah. No, your submission is only this. Based on an interpretation given by the ombudsman, the eligibility stands in their favor.
Yes. So therefore, they
We look into it. We are not deciding it. You're right, that argument for you would be available. What is sought to be argued is that this is basically a challenge to the ombudsman. An ombudsman has given a particular interpretation, which he is contesting. If the ombudsman order is upheld, then the eligibility continues. If it is set aside, the eligibility goes. That's his submission. Very well, if it is on record, not record, file it. Just say that, just re-notify the petitions for hearing on. You, all of you have filed your submissions?
Yes.
Everyone? Who appears from there?
My lords, I'm appearing for R4.
Just give it conveniently.
Your Honor, I appear for respondent number 1 for BCCI. Our submissions are on record.
Yes. Don't make any submission. He has made, we will hear it in the composite.
My lords, even our submissions are on record, my lords, for R4.
Very well, thank you. Give it a convenient date. Respondent number 6, counsel for the respondent number 6 states he shall also file written submissions. Let the same be filed within 4 weeks. See, we want complete, not in piecemeal, complete. Very well. You appear for whom? By the counsel for the respondent number 5 also state, 5 and 6 says, they shall also file their additional submissions, oblique submissions. Okay,
2410.
next.
Obliged, my lords.
Twenty-eight, Srimati Shubha.
Yes. Yes. Ma'am, give us the floor. You are ready now, ma'am? You are ready for arguments? Yes, sure. The floor. The short issue. From which date the regularization has been granted? Ma'am, this issue is covered against you. Supreme Court has clarified it. What is the only ground you have challenged? This issue has been now clarified thereafter by the Supreme Court. It is not a cut-off sacrosanct date. Even subsequently also they complete 10 years, it could be given. Pardon? Very well, then why did you continue him for so years? Is he continuing today also? You have granted him temporary status? Yes. Well, now, which is this post? How many years they have worked? 97, we are here now, 327 years almost they have worked. From on a pure cutoff date, the law is well clear now. Supreme Court has clearly held. Now they are sweeper. Now surely a requirement of sweeper would be there in the department. Why? But there was no stay here. Now, today there is a stay in the before this court. What do you say, Mr. Gupta? But you are continuing. At the request of counsel for the petitioner, re-notify.
811.
Is there any interim order continued? Interim order implementation. Let's continue now. Okay, then don't say that. Let's continue. Okay.
29.
Passover. Pass.
30.
Serial number 30, my lord.
1 minute. Just show us this.
Same 30, my lord. Today I am out of station, my lord, for a court work only, my lord. Kindly have it after 2 days, my lord. So I have to from here. I have to go to another court.
I appear for the petitioner in the matter, my lords. Serial
Respondent.
number 30.
Start date may be given, may not 1 week or 2 days. Matter pay scale, matter relating to pay scale.
Based on record, both the parties jointly. We pass over again here, this issue. This issue is covered, Mr. Shetty, not against him. He's not entitled. Very well. Call the council. You are the council? Yeah. Okay, call it. Pass over.
Serial number 30, I appear for the petitioner, my lords.
My lord, I appear for the respondent, my lord. Today I am have inconvenience. I have come out of station, my lord, from court work. 2 days or next week it may kindly be had.
Counsel for the respondent seeks an adjournment on the ground that he is out of station. Adjourn to
511,
Oblige.
31,
pass over. This probably. Oh, that's true. So we can just call the passwords.
pass door matters. Serial number 9, Shurira,
He says only that this portion is to be marked. That is stirring against me. No, not, though, just say this matter, this appeal was listed on 29/8/2024. When this court, at the request of counsel for the appellant, had re-notified the matter for today. So there is no appearance for the appellant even on the second call, re-notify the appeal tomorrow. In the interest of justice, re-notify the matter tomorrow.
39,
Yes.
serial number 10, Prashant HS. 10.
Not for attention of both. There are much more as to property sales holding option.
Everything done.
Everything is sold and moreover, validity, food condition order. All the conditions are not done. In fact, we submit the demand, let's check before this court, stating that the amount amount is ready in the bank, I'm not withdrawing it.
He did not deposit that amount also.
Single rupee is not deposited. He files a stating that he produces a check of 1.
No, after the interim order of 27/9/23, he did not deposit.
Single rupee. Again, traditional order is not, second time also he got 6 of.
27/9/23 and thereafter. Yes. Also.
Twelve, Srimati Shwetanand. Seal number 12, Srimati Shwetanand.
Just shows the file. This is item 12.
12.
Morning shift. Yes, pass over.
13.
Yes, Mr. Kulkarni. What do you say?
Next.
Yes, show us now what is the error in this? Ajay Chaudhary. So that has been now dealt by the. Yes, tell us, make your submissions. You were before the tribunal? Yeah, right, you were other grounds also. Yeah, tell us.
And as far as during the pregnancy of the matter, they come up with the charging. And they said that now that we are issuing the charging, in terms of the vulnerable corporation case, that's this problem we have.
What is the stage of the proceedings today? They have given 6 months now. Then what is the difficulty, Mr. Kulkarni? What is his designation? There is an ad hoc, there is an ad hoc now disciplinary authority. Okay. That gentleman who issued charge sheet.
He is the one requesting that case.
Oh.
Therefore, we are appointing a half, in submission to the water case. The charge which was pertaining to the tribunal. Based on which this direction has been issued by the tribunal. He is itself is the non-encashment lawyer.
How does the tribunal deals with this submission?
They say that the authority is the issue of tribunal to validate the party. Therefore, subsequently, because he is found to be a medical witness, he is taken as a this thing.
10, 12 ಮತ್ತೆ ವಾಪಸ್
Who appears for the respondent? So,
ಶಾಂತಿ ಭೂಷಣ್. ಹೇಳಿ, ಇಂಗ್ಲಿಷ್ ಹೇಳಿ. ಇದೊಂದಿರ್ಲಿ ಸ್ವಲ್ಪ ಅವ್ರು ಹೇಳ್ಬಿಡಿ.
These are the list. There should be a charge sheet. Then there are petition. But what Mr. Kulkarni, what you are saying is right, because ultimately the person who is a material witness, he could not himself take any decision to issue a charge sheet.
Yes, he can't be a discipline of that.
There should be an independent application of mine that these are the misdemeanors on the part of the petitioner, whether these misdemeanors are misconduct within the conduct rules, and there should be a issuance of charge sheet. And then proceed.
But for submission, there should be a fresh charge sheet that is a interpretation. This charge sheet is it's a validity directive.
But that's too technical, Mr.
No, my submission is post the document.
That's right. Suppose for a moment, the new disciplinary authority says, yes, these charges are sustainable and need to be inquired. What is wrong?
The new disciplinary authority can't say this charge is sustainable. Yes, you should say that you want. Thereafter, what happens is, as on the date when this tribunal passed the order, there was no charge sheet in the area. Next question of the only operation case of
Issue notice. Issue notice. Having heard Mr. Kulkarni, the counsel appearing for the petitioner, just say this. It is the submission of Mr. Kulkarni that the charge sheet was issued by an authority who was interested in the proceedings and who was concerned with the inquiry as a material witness, and as such could not have issued the charge sheet. So he states that the illegality which has crept in the issuance of the charge sheet shall continue even if an ad hoc disciplinary authority has been appointed. In other words, it is the submission that an ad hoc disciplinary authority has to independently take a decision whether a charge sheet need to be issued for the alleged misdemeanor. Issue notice till the next date of hearing, the direction of the tribunal for to conclude the departmental proceedings within 4 months shall remain state. Just give a date.
12th November. 12th November.
But you have challenged the
Date will be out.
It's not the question of the.
Yeah.
Date is the 12th November. Madam, submit November. Madam, submit November. Yes, ma'am.
We'll see that, Mr. It's only put off. How much wages you are getting?
So many years that we start to be.
How much you are getting?
25% are some 37.5%.
Like subsistence allowance?
That is not subsistence.
No, you are right. It's technically not subsistence.
Government tax code gets out of the 10,000% complete. And in that 10,000, 25% something which will work out to 2,500 or so. 2,500 is a pocket money, you know, the children going to school.
Yes, we'll look into it. Yeah, so, just next one.
Serial number 21, Shri Nagarajappa.
Yes. Okay, 519 you retire. Yes.
Page number 130. Item number 3 will not be conditions stipulated that he has to complete the PhD within 7 years of his appointment. That is item number 3.
Where is the translation, Mr.
Statement of objection
Where is that 7 years in this?
Statement of objection 520 at that point. That's item number 3 is in
No, 3.
His objection is 520.
3 is something which is different. Where is 7 years here? Right. Okay, now what is the next point? Tell us one thing simple. Did you complete, how many years took for you to take, get PhD?
According to conditions stipulated in the appointment order, around 7 years. But I am not speaking about that. But a lot of times, the reference made is a backlog vacancy. That is item number 1 of the appointment order. It states, as far as 2001, this is backlog vacancy.
But how does it will make difference? The condition would still be applicable.
This reason, the condition is not applicable for this reason.
Why?
Was appointed under the backlog vacancy of 2001.
Doesn't make any difference.
There was
Backlog maybe 20 years back, you were appointed today.
but the circular referred by the endorsement is what the kind of.
Which page?
Endorsement is at page 80. 80. Based on circular you are on page 80. Reference is my lord. This office circular is dated 2/5/2005.
2/5/2005. Okay.
The appointment of the appellant is my lord in the year 2004.
See, just read 82. Such candidates will be required to complete PhD from the date of joining.
7 years.
It has to be that way.
But his appointment was in the year 2004. Based on backlog vacancy.
Let's test this argument. Let's test that argument. There was a vacant. What is his date of birth? Let's assume his date of birth was 1970, hypothetically. There was a vacancy of 1969. There was a vacancy which remained till 2004. Against that vacancy, he was appointed. He was not even born when the vacancy arose. Can he still say that since that is the vacancy, 7 years will not come in? The rule, you getting the point? I hope we are clear. When he was not born, there was a vacancy.
That was approved subsequently.
He joined subsequently on that vacancy in 2004. There is a stipulation that you will get the PhD qualification within 7 years. Why not? That will be applicable. Tell us. You can't say so. It's ultimately the date of joining is relevant. How is it relevant? Vacancy is relevant for your joining. You can't foresee against a vacancy of 2001, you will join in 2000. You can't foresee. The requirement would only come when you actually join. Look here, now you have joined without PhD. Without PhD is a requirement. Without PhD you are joining. We are giving you 7 years. Get that eligibility of having a PhD in next 7 years. What is wrong in saying so?
But because of the lapses on the part of the institution, already suffered, they are not being allowed, was not being deputed immediately, but stated in.
Where? Deputed where?
To the institute, for various reasons, because they are being harassed by the correspondent. They are not being deputed immediately.
How many years you took, you got the PhD after how many years? 17, that means almost 13 years. 13 years. 13 years. Yo, what stop at me? Did you raise that issue at any point of time? You should have come at that time, saying that, look here, for these reasons, they are not deputing, they have put a 7 years condition. They can't suppose meet that condition of 7 years. My appointment will be terminated. That's the triggering point. But after 7 years are over, you can't contest it. And mind it, not even 7, 6 years thereafter also they gave you time. When did you terminate him?
Not dedicated for increments from December 2001. That has been denied.
That's all, only increment. Then it's all. 2013 that they did not give you and you complete.
That has been rejected about the increment.
So only one increment was denied to you.
December 2001.
Not in these facts.
Even the AIC regulations, the respondents are bringing the AIC regulations, governing the appointment. These of 2011, 2012, and 2016. There was no AIC regulation prescribing 7 years at the time gap or completion of the case.
In those cases,
in present cases, not the AIC regulation used by the respondent. Or subsequent, there was no such conditions stipulated by the AIC during that period of appointment.
but in 2004 there was a condition.
2004 there is the condition.
That's all. They followed that. I don't think Mr. Nagarajappa, I don't think we should take it further. The challenge in this appeal is to another date, 24 July 2023, passed by the single judge in this petition 7475 of 2020, whereby the single judge has dismissed the petition filed by the petitioner. By observing this status, however, it is open for the petitioner to approach the competent authority if so advised. So the petitioner has the challenge. The petition was filed by the petitioner, by the appellant, and those challenging the endorsement dated 21/7/2018, issued by the respondent number 3, that is Director of Technical Education, Bangalore. the appellant was appointed as an assistant professor in the Department of Mechanical Engineering, and the backlog recruitment as per appointment order dated 2011-2004. The considered case, no, just 2004. The petitioner has, it is a considered case that the terms of appointment also stipulated that the petitioner is required to complete PhD within 7 years from the date of joining, failing which increment shall be stopped until PhD is earned. The petitioner completed his PhD degree in the year 2017. So it is also a considered case where the petitioner appellant superannuated on 31/5/2019. So the grievance of the appellant before the single judge was that he has been denied the increment only on the ground that he did not get the PhD degree within 7 years. 7 years of his joining. The submission, the learned single judge has dismissed the petition by stating in paragraph 8 and 9 of the impugned order as under. Learned counsel appearing for the Mr. Nagaraj Pal, learned counsel appearing for the appellant would make twofold submissions. One, according to him, the said stipulation, the vacancy against which the petitioner was appointed as an assistant professor in mechanical engineering, Department of Mechanical Engineering, was a backlog vacancy of the year 2001. And in that sense, the said stipulation of 7 years for procuring, for completing the PhD would not be applicable. Two, even in the subsequent selections of the years 2013, 2013. No. What was the stipulation? There was no stipulation put after that.
Earlier to that, there was no stipulation. Before.
Would submit.
ACT is silent as on the date.
Would submit that no such stipulation was put to the appointments made before the year 2004. We are unable to agree on both the submissions made by Mr. Nagaraj for the simple reason that the terms of appointment issued to the petitioner stipulates so that is he is required to complete the PhD within 7 years from the date of joining. Concedingly, the petitioner would able to complete the PhD after 11 years of his joining, that is beyond the period of 7 years, so stipulated. Even if there was no stipulation for the appointments made before 2004, from when there is a stipulation in the appointment letter issued to the appellant, the appellant cannot disown the same. Moreover, till the filing of the petition before the learned single judge, the appellant did not challenge the said stipulation in the appointment letter, except stipulated. The only submission on this of Mr. Nagaraj was that the petitioner has been making representations in that regard. We are afraid making representations and not would not help the case of the appellant. Appellant that the stipulation of 7 years put by the respondents in the appointment letter to enable the appellant complete the PhD shall be applicable as the terms of appointment clearly stipulates. The appeal being without merit, on the same is dismissed.
Serial number 23.
put in possession of lands and converted also. When these proceedings were initiated, I brought it to the notice of the President that earlier proceedings have been brought. Despite which not they allowed
by the same report, earlier proceedings were dropped.
by the same. Next day, my faculty schema, my objections at page 29 paragraph. Though earlier this court has dropped the proceedings against some of the after the proceeding that established only this court not for the owner has been granted properties. Is well settled not proceedings like those take the case that if all the materials produced are considered as even then no case of being there, then he has to drop the proceedings at this time. But the documents produced are lost copies and notarized copies. They cannot be accepted as preliminary state. But would that be a reason for rejection? But can you drop the complaint?
See, but tell us why not? The Xerox copy, the originals are not produced. What will the court?
Very same proceedings were dropped earlier against it.
I know, but what is the basis for them? Even if you have to.
They are also not the copies that were.
So you will produce the certified copies. Early certified copies should have.
They were certified because I am successfully purchased and I secured it and then placed it before them. But it's not that the other side is not there. That was. He could have made a way. But trying to look at the complaint at page 36.
But is it your case that earlier proceedings were dropped?
No, he is not the person. We were the one paid on the value. But he is a speculator. He files the complaint. Can you see page 36 and it said, he makes an anonymous complaint.
No, sir. No, sir. Stems.
We'll issue notice.
Yes, the proceedings are unnecessarily. And look at the complaint. They speculate. It was 80 acres, 6 quotas of land.
We'll issue notice. Let him come.
Yeah.
Issue
And
notice.
he is every time pursuing about these matters.
We'll issue notice. So accept notice for one. That notice we issue to respondent. See, in the complainant, you need to hear it.
But I am not on that. And you look at his complaint. He has said, this is what it says. Survey number 98, 80 acres, 60 cars. And this land is permit for two garaya without any sanction of the government or any local people have made safety on the basis of the legal reference farms. By paying right to local reference.
Just say one, the submission of the council for petitioner is by drawing our attention to paragraph 11 of the issued order, wherein the court has noted the submission that the same section of the accused persons, after considering the fact that the grant has been established only on that ground. A grant has been established only on the ground that the same was sought to be proved on the basis of Xerox copies.
And notarized.
Xerox oblique notarized copies. Submission of the learner counsel for the petitioner is that the Tehsildar, being the common respondent in the earlier proceedings and this proceedings.
Yes, ma'am.
Would have very well established the dropping of the proceedings against some of the accused.
And the grant also.
And the grant also. This include those accused include you.
I was not there.
And also the grant. It's issue notice. So accept notice for one, let notice be issued to the respondent.
2210.
Stay I saw.
Is the date of hearing.
But the date of hearing is on the 13th of this month.
We have been informed, we need the stay prayer.
The stay I have sought for, page 21. I sought for further proceedings being stayed.
The counsel for the petitioner has specified the stay of the proceedings. He informs us that the date of hearing, next date of hearing before the special court is
On 21st of now, September.
September. On the said submission on a request made by the petitioner to the special court for adjourning the matter beyond the date fixed by this court in these proceedings, the special court shall adjourn the proceedings. Just give it. So you make a request, they will adjourn it beyond this date.
Yes, please.
2310. Serial number 29. Sri Jaikar Shetty.
There is one judgment. This is upload. Nine.
29.
Can we access on our system also? We can do this. We can access it. Mr. Shetty, this issue is covered. Now, the issue is this 4,800. They are seeking 5,400.
Please.
4,800 was given through ACP,
MACP. Ma'am.
MACP.
That is very clear on ink page 67. Ma'am.
Who appeared for the respondent?
Holla appears, ma'am, year old.
Mr. Holla.
Yes,
Did
sir.
he appear in the first round?
First round, is due.
Pass over.
As colleague was there. Pass over.
We'll just pass over. Just look into this judgment.
Please, ma'am.
This is Union of India versus MV Mohanan Nair.
Please.
This issue is covered under this.
Because it's not under a regular service, my lord. That is the only point. Only MACP, he got it.
That's the point.
Please.
It's not in the regular service where he gets 4,800 after 4 years. He gets
Then we can't.
the benefit under MACP.
MACP.
Then he will not get that after 4 years.
Please.
Yes, we will pass over.
Please.
31, Shri Pramod.
Yes, Mr. Pramod.
Please, Milords. Milords, the respondent applicants, Milords, are working in the Defence Estate Office, Milords, as SDO 1. They entered into the service, Milords, in the year 2010, Milords, as SDO 3, Milords. Milords, in the year 2016, Milords, there was merger of SDO 2 and 1, Milords, as 1, Milords. Milords, the applicants have filed the OA seeking for a relief of revised pay, which is applicable to the SDO 1, Milords. Now the tribunal, Milords, after considering the case, Milords, has allowed it in part, saying that they will be entitled for the revised pay, but it will be after 5 years is what the tribunal says, Milords. Milords, that we have challenged, Milords. Milords, I filed even a written submission
But
also.
why are they not entitled to SDO 1?
They entered into the service in the year 2010, my lords, as SDO 3, my lords. My lords, this was merged, my lords, page 66, my lords.
With 2?
No, my lords.
1 and 2 got it.
1 and 2 got merged as 1, my lords.
As
That is,
1.
that is from 11 to 2016, my lords.
Okay.
Lords, what now they are seeking is, my lords, that they should get the revised pay of the 1, my lords, from the date of entry. That is from when they entered into service in 2010, my lords.
Oh.
But the tribunal said, yes, they will be entitled after 5 years from 2015. Lords, we are
Now,
contending.
no, when was the merger took place? 16.
2016, my lords. That is 11th of February, 2016. Page 66 is the merger order. Lords, here, my lords, the facts are like this, my lords. My lords may kindly see page.
Is notice issued in this?
They have appeared, my lords. In fact, it has to be heard.
Just pass over, let the council come.
Please, please.
Which is the number? 12. Next month.
Serial
all
number
the
10.
password.
Shri Prashant,
Which number, ma'am?
serial number 10, sir. Serial number 10, Shri Prashant HS.
Someone appeared, no?
One appeared, he told, second time passover it was taken. Standing there. So if I kindly look into the petition copy. The order impugned was extension of one-time settlement. My amount was not paid, I auctioned the property. All these things were not placed before this court. And ex parte interim order was taken. Even till date, this court granted some conditional interim order. Still date, the interim order is not complied. His only contention before this court was he paid me 3.25 lakh.
At 2:30 minutes, he's on legs before.
Doing, we are just taking up this matter.
Sorry.
Okay, you argue the matter. No at 2:30. We are dismissing this petition. What is there?
Senior is held up, not in other.
It's all right.
I make one submission. Before this court, he produced one check stating that 3.25 crores is ready in bank. Bank is not encashing. The check which he produced before this court, my lords, from the bank, the concerned bank, we took the statement, original statement.
No money.
2,000 rupees is the balance.
Lord, it is there.
2,000 rupees is the balance.
He has
The council,
Please.
5 minutes.
Please.
Well,
I'm sorry, my lord. My lord, this case pertains to interpretation of section 14B of the Provident Fund Act. It is an undisputed fact on record that there was a 7A inquiry. And in the 7A inquiry, the amount of default has been derived. It has been paid also along with 7Q interest. But unfortunately, section 14B has been invoked subsequent to payment of section 7A orders. And that has been called into questions by the respondent before the CGAT.
So we are only concerned with 14B.
14B, only 14B. And the relevant page of the order is at page number
Now
27.
that has been reduced from 19 to 9 lakhs.
50% has been reduced from 14 lakhs. So,
What are the slabs which you have?
well, and I have also stated here also, because slabs also in para 32A, my lord. Your lordship may kind. Para 32A. Para 32A, my lords. Para 32A of the EPF Act.
Which page?
No, not, I have not extracted.
Just show us that.
Yes. Because this amount has been calculated based on same.
of the scheme.
Please, madam. 32A.
Yes.
Well, there it is mentioned 5%, 10% and 25%.
This remains as it is.
This remains, because this has not been challenged
No.
and this is enforced.
What is the period of 14B?
14B, Malad, there is no such period because it can be.
What is the period for 7A?
7 in 1992. From 1991. 1990 August, July 1990 to August 1997.
July 19,
90 to August 1997.
1990.
97. Malad, because of the reason that they have not paid any amount.
Ma'am, this is July 1990
Please, Malad.
to
August 1997, Malad, the order was passed. Act determined.
when were they covered?
16/9/1993 notice was issued, came to be issued for the period covering from,
4690.
please, madam, July 1990 to August 1997. 7A inquiry has been initiated. Only notice has been given at the earlier stage stating that you are covered under the EPF. That has been challenged before this honorable court.
A notice has been issued.
They have paid 50% also, whatever 14G has been passed.
They are paid.
That is, they have paid 50% also. Because 50% has been deducted, but that means the.
So they are paid 50% of 983,500.
90 lakhs, they have paid that amount, they have deposited. Out of
But
it.
you say it should be 19 lakhs.
Yes, because there is no provision for the either CGITF or for the commissioner to reduce the penalty. This is a penalty class.
This respondent is under Canara Bank.
Yes, madam, can bank. And there is no such jurisdiction lies with the CGIT or with the commissioner to reduce the penalty because it is settled position of law that under section 32A, it has been notified.
But tell us one thing.
Please,
Suppose for a moment your claim, you are imposing the penalty or the damages or compensation under 14B.
Please, madam.
Suppose in this 19 lakh, judicial review is still open.
Please, madam.
Judicial review is still open.
Well, that is within the framework of the statute.
You are right.
Please, madam.
Suppose the appellate court comes to a conclusion, it is not 19 lakhs, it should be 10 lakhs.
As per the calculations.
As per the, but you can't say that the appellate court could not have done it.
They did not say that. They did not take that contention that it is wrong calculation. They say that it is not maintainable because I have paid the interest on the principal amount of 7A and 7Q and hence 14B is not applicable. That has been challenged and which is incorrect because
14B
number of
provision is
cases.
there, yeah.
there is number of cases which is covered under 14B. Even latest also
Issue
mens rea.
notice.
Mens rea is also not applicable to such cases. That is what the latest Supreme Court judgments also says. The only question is with regard to that. We have already, yeah, we have completed it.
There is no appearance for the respondent. Let notice be issued to the respondent.
Emergent notice may kindly be requested.
Pardon?
Emergent notice may kindly be requested.
Returnable on
2110.
2110.
Nine.
My lord, this matter was heard by your lordship for some time. But my lord, this petition itself is not maintainable for the fact that, my lord, on submission made by both the parties, tribunal has passed the order of consent order. Kindly see page 36, my lord, operative portion of the order of the tribunal. Para 5. The learned counsel appearing for both the parties jointly submit that issue involved herein is squarely covered by the order of the tribunal dated 13/9/2023 passed in the original.
Which page you are reading, Mr. Ola?
36, my lord. Ink page 36.
Ink page, that's.
Order of the tribunal, para 3.
But see, what we see is the issue is only this, that if you get 4,800,
Hardly, yeah.
after 4 years, you should get 5,400.
Yes, ma'am.
But you get 4,800 through MSCP.
Yes. That is covered, my lord, that I take your last directly the.
But that 4,800 is in the eventuality that you in the normal course, not through MSCP, getting 4,800, you will get 5,400.
No, my lord, the Superannuation case says otherwise. Page 69, my lord.
But Mr. Hola, this issue seems to be covered by the judgment of the Supreme Court in Mohana Noyer.
Superannuation case also Supreme Court decision is there.
Very well. Let's see that. And this issue see, the sum total is maybe this or there is some judgment. If 4,800 has been given through MSCP, then the benefit of 54 is not applicable. Then it is not applicable. The scheme doesn't even contemplate. Okay. That is in the normal course when a person is given maybe on promotion on for any other reasons, 4,800, then it is something, after 4 years, he will get 5,400 fixation. But not in this case where 4,800 has been given under the MSCP, next after 4 years, 5,400. That's not contemplated.
Two paras of this decision of the Madras High Court, my lord, which has been confirmed by the High Court. I mean, Supreme Court.
You're right. But you're right. But ultimately, to our recollection, there is this judgment or a subsequent judgment where actually this issue was gone into. You show us from the scheme of the MSCP, which says 4,800 after he gets a 4,800, after 4 years, he will get 5,400. Does the scheme contemplate?
MSCP scheme doesn't say that.
Don't contemplate.
NFSG is my lord, a separate scheme that is brought into force subsequently, or conflict of the pay revision.
Even as for R1, my lord, he has to complete 4 years as a senior administrative officer, not administrative officer. On that count, because that order is still there. And also, still, my lord, he has retired as an administrative officer. So he has to complete 4 years.
So what is happening is, you are getting 4,800 as MSCP, after 4 years, another MSCP. That is not permissible. I think this issue is also settled by other judgments based on that also. MSCP benefit for 5,400 is not once you got 4,800.
It is not NFE, my lord. NFS is non-functional selection grade.
Right. But when you got 4,800, you got through MSCP.
Not regular service.
5,400 is non-functional selection grade, you are right.
Yes,
But that benefit of non-functional selection grade would not get, you would get for 5,400 when you got 4,800 through MSCP. That's the judgment. Getting, you're right, we understand that. But once that 4,800 has been given under MSCP, but if it was in the normal course, you got 4,800, then you will say non-functional grade, after 4 years I am entitled, we are with you. But when you got 4,800 not through that normal channel, but through MSCP, you will not get 5,400.
No, that is the ratio of the Madras High Court, my lord, confirmed by Supreme Court.
We will have it, I think, in a day or two. To my recollection, this issue has been possibly by
Covered.
one of the orders also.
I will also go through my, come back.
There is Mohana Nair, and which is the other judgment?
Lords, this is the Directorate of Enforcement, my lords, versus
Sudesh Kumar.
Sudesh Kumar.
What does it say?
Lords, it's same issue, my lords.
By which court?
Supreme Court.
Just show us. Does it say so?
Please, my lords. It refers to the even the schedule of CCS pension revised rules, and it refers, my lords. I'll just point out.
Citation.
Report to law. Either court.
Mohan Nair judgment is also
Even that
referred.
is also referred to and said that when it is NFSC, my lords, it is referred to that. Para 7 onwards.
Just look into this, Mr. Hola. You also, Mr. Shetty,
Please,
look into
please.
it. We will also look into
I will
it.
get the judgment.
We'll have it next week. Okay. At the request of counsel for the, no, just re-notify next week.
$17,900. Sir. $31, she promote.
Here, my lords.
That's fine.
Petitions. Lords, in this case, my lords, the respondent, my lords, applicants, my lords, they entered into the service, my lords, in the year 2010, my lords, as SDO 3, my lords. My lords, next promotion post is SDO 2, SDO 1, my lords. In the year 2016, my lords, that is on 11/2/2016, my lords, SDO 1 and 2 have been merged, my lords. And SDO 1 and 2 have become one post, my lords. And this SDO 3 has become the other post, my lords. My lords, the claim of the applicants is that they should get the revised pay from the date of entry of that of the SDO 1, my lords, is their claim. And the tribunal, my lords, after considering the case, my lords, has allowed it, saying that they will be entitled to it after 5 years, my lords. That is from the year 2015, my lords. That we have challenged, my lords, saying that they are not entitled. Lords, even the written submission is also filed, my lords. And even earlier judgments of Jabalpur and principal bench were placed on record to point out that this issue has been decided, my lords, but the tribunal negates that and has passed the order. Lords, may request my lords to kindly see page 45 for a moment, my lords.
So after 5 years, there is a revision in pay scale.
No, my lords, after 5 years, prior to merger, my lords, after 5 years, they were entitled for a promotion to the post of SDO 2, my lords. 2. And after 3 years in this SDO 2, my lords, they are entitled for promotion to the post of SDO 1, my lords. That's the position. But here they are seeking for from the date of entry itself, my lords, but it has been given after 5 years. But the merger has taken place in the year 2016, my lords. Their date of entry is 2010, my lords.
So 5 years, so before the merger. So before merger, they were separate.
Before merger, they were separate.
2, 1 were separate.
They were separate, my lords. Lords, here,
But
my
on,
lords,
on what ground the higher pay scale, revised pay scale has been given?
my lords, I'll just point out, my lords.
Tell us what is the basis? What was the scale they were given when they were appointed?
Scale which was given to my lords is lords, page 57.
Hmm.
My lords, fourth column, my lords. My lords, on the second column, we'll get the SDA grade 3. Then fourth column, my lords, has the pay, my lords. This was the pay which was given, my lords.
It is 1200.
Please, my lords.
1560.
Please, my lords.
What is the revised now of this? What has been granted by the tribunal?
Lords, the tribunal, my lords, by its imputed order is saying after 5 years, my lords, they are entitled for higher pay, my lords.
Which page?
31, my lords. They are not.
You know, which pay? What does the tribunal say? What was their claim, Mr. Holla?
Claim is, my lord, after 5 years, as per the scheme, which is dated, my lord, 15th September 1995, annexure A4, page 60. My lord, these pay scales were given, my lord, in pursuance of the arbitral award. And I mean, they.
No, but what is the scale? 1200, 1560 means what? What is the higher scale given now?
My lords, they are asking for benefit of pay in the pay band 2, rupees 9,300, 34,800 plus grade pay of 4,200, my lords.
From how can
Corresponding to the pay scale of 1,400-2,300 pre-revised.
That's right, 1,400, 2,300.
Please, my lords.
So after 5 years, they would get this. 2015, they would get this. 1,400, 2,300, which is revised as 9,300 dash.
Please, my lords.
That's right. Now, is this scheme, are you disputing applicability of 15/9/2000 scheme?
Lords, we are stating that there are certain riders over there that is not applicable.
Show
It is
us
applicable
show
to
us
them,
the scheme.
but they are not entitled.
Show us the scheme.
Please, my lords. Lords, annexure A4 at page 60 is the scheme, my lords. Lords, prior to this, may I narrate few facts, my lords, which would be relevant, if my lords permit. My lords, may at the first instance see page 45 for a moment, my lords.
So you just see 61.
Please, my lords. 61, my lords, 3. It says incumbents in possession before 13/5.
So if you see B, SDO 1200, 2040 will become 1400, 2300.
Please, my lords.
And you see just at the bottom,
Please, my lords.
B, minimum period of service for placement in this period 5 years.
Please, my lords.
Carrying
lords, may kindly-
1200 to 1400.
My lords, may see the serial number 3, my lords, incumbent in possession before 1982, my lords.
May be placed.
So these persons have entered into the service in the year 2010, my lords.
Okay. Now, was this date 13/5/82 changed?
No, my lords, this is not changed. Persons, this is prior to 82. In respect of persons after 82, it is available at page 62, my lords, para 4.
After place be placed in the revised
So and
scale
so
of
and
pay,
so,
the
on or after 13/5/1982, may be placed in the revised
appointed in
scale of pay the
calendar
following manner.
revised if they have been appointed with a qualification of certificate or diploma in draftsman from recognized in not less than 2 years. If they have been recruited with a qualification or certificate diploma of not less 2 years. Without 1 year, I think they will continue in the scheme.
And here, my lords, the applicants are diploma holders without experience, my lords. Any kind of direct recruitees
They are
without any,
diploma holders.
without any kind of experience, my lords. And the relevant next,
Of not less than 2 years. No, but where is the experience in B, page 62? Page 62,
please, my lords.
where is the experience required? 1 year.
1 year experience, it is-
as draftsman.
1 year experience as draftsman if they have recruited with the qualification of certificate or diploma in draftsmanship of not less than 2 years.
But tell us one thing,
But one more thing, my lords, clause 6 may be seen next page, my lords, for a moment.
page.
63, my lords, clause 6. Lords, these orders shall not apply in respect of cadres of draftmen where draftman grade 3 is the first entry grade by direct recruitment with further promotion to draftman 2 and grade 1 with respective qualification exactly similar to corresponding to CWD category.
Yes.
In fact, my lords, prior to issue of this 1995 scheme, my lords, the department had even also recommended to revise, my lords. Actually, that is also available at page 115, my lords.
Was it by direct recruitment?
Yes, please. Please.
And what is the finding of the tribunal on this?
Lords, it doesn't say anything about that, my lords. It says after 5 years they are entitled, you can't deny them. And there was in fact one more case filed by the very applicants, my lords, that they were not getting promotion. And there was some amendment to the recruitment rules and direct recruitees to the post of SDO 1 was being taken, my lords. So they had filed it. It was allowed in their favor. Department filed the petition, my lords. It was dismissed saying that they are entitled to be considered, and pursuant to which they have been also considered and promoted to the SDO 1 also later on. Even that is done. That has.
Please say, Mr. Ola.
We are covered under the scheme, my lord. Of course, we are not draftsmen, my lord. Kindly see our designation, my lord. SDO grade 3 and SDO grade 2. That's page.
We'll put it for hearing. I think this requires some consideration.
Please.
Just re-notify the petition for hearing on submissions we filed by the council.
So I have already filed it, my lords.
Mr. Ola, you also file your submissions.
Very well.
With the respondents to file their submit, the learner council for the respondents to file submissions within 4 weeks, list on.
2110.
Much.
Next.
Number 10.
Lords, I'll just make this statement. Let them present the check today. Lords may have this matter day after tomorrow. If the check is not encashed, I am making a statement. Your Lords may dismiss this writ appeal with very exemplary costs.
But tell us, Mr. Ravi Shankar, how is this petition maintainable also?
Lords, the writ petition was filed, my lords, kindly see, my lords, the original order which was passed.
But tell us, when was the interim order passed?
Lords, interim order was passed, my lords, what happened? Interim order in this before this honorable court, the division bench, my lords, was passed on 23/5/24. Lords, now
27/9/2023.
23/5/24.
Before that also interim.
Before that,
We see the first
23/5/24
order.
is the order with which we are concerned, my lords. 23/5/24. Lords, earlier we were required to pay 1 crore rupees. We did not pay. 23/5/24, your lords.
But why should we show indulgence?
Lords, I'll just submit, my lords, because one of my property, I'm losing it for a very minuscule amount, my lords. Sometimes, my lords, when we undertake business ventures, it is but natural that we may take some risks and we may lose out. But not to this extent that I'll have to be wiped out, my lords. That is the reason. My lords, now I'm making a statement, my lords, only to show my bona fides. If it is not encashed, my lords, your lordships may consider, because on the threshold, since your lordships have passed an order on 23/5/24, I made a statement before the court that they have not encashed the check. Notes, they have not presented the check for encashment. The reason why I'm making the submission is, notes, I have about 25, the person who is now given the check is a financier. He's about 25 crore rupees of deposits, which is there in the bank. Notes, his understanding with that bank, Superannuation Cooperative Bank, is as and when the check is presented, they will dilute the fixed deposits and then they will have to clear the checks. That is the understanding he is having. I'm only saying, lords, now that an order is passed, lords, ultimately, if your lordship feels that writ appeal itself should not be entertained, lords, I'll come on the merits later. Because if this is not complied with, there is nothing which I can submit on the merits of the
No
matter.
further indulgence, Mr. Ravi Shankar. See, to first, second, how
Lords,
many times?
only, lords, I'm not seeking for any indulgence, my lords. Lords, I'm not seeking, lords, I'm not seeking for any.
Property is sold, my lords.
Lords, may I just say this, my lords?
Everything is over.
Lords, I am not seeking any indulgence. My lord, the difficulty
There's no
was
question of
after we
reduction.
gave the check. Lords, after we gave the check is not presented. Lords, let them say the check is presented. I will withdraw my writ appeal, my lords. I have given them the check. If they say that the check is presented, I will not pursue this writ appeal.
Have you presented after that?
Lord's check was issued by one Sudhakar, third party. Lordship, may kindly look into this.
What is this?
This is the statement of the check given. Original statement.
So I am
of the
making
bank.
a statement. If the check is
But
presented,
since
this person is
2023
having an adjustment. He is having 25 crore rupees in that account.
1,000 rupees is the balance, and he is filing a IA along with this check, telling that bank is not accepting the check, not encashing the check.
Lords, let them present the check today, my lords. Your lords may have this matter tomorrow. If this is the state of affairs. Lords, this is the reason why I am submitting, my lords. I will also get an affidavit filed, my lords, of the concerned person.
But they, no, Mr. Ravi Shankar.
Lords, I am not seeking an indulgence. My lords, I will produce documents to show
Minute, please. This order was passed on.
23/5/24.
Now, this is something which he is showing of 5/6/2024.
Lords, this is essentially what I submitted. My lords, this person, that is the person who's now issued the check, Sudhakar, is having about 25 crore rupees in his accounts in Superannuation Cooperative Bank. Lord, this is an SB account, my lords, which he is operating, for which the check is issued. Lords, lords, let them present the check today.
See, if you are going by this, although an order was passed on that day, there was no amount lying.
Lords, there was about 25 crores in their bank, my lords. 25 crore rupees is what is.
You tell us on the day when the order was passed,
Yes.
what was the position?
Lords, the position was 25 crore rupees is standing into the account of the Sudhakar. Lords, I just submit, lords. Lords, I've seen that. I've got a copy. Lords, well, just, Lord, this is in the FD accounts. The understanding with the bank is, as and when any check is presented as against this account, Lords, the funds from the FDs will be transferred and every check is honored. Lords, I'll be in a position to demonstrate. That's the reason why I said, I'm not saying anything more, Lords. Let them present the check today. Tomorrow, your lordships may have this matter. If the check is not encashed, Lords, I'm making a statement. Your lordships may put me exemplary costs.
Permits me, I can talk. Lords, in this case, only extension of one-time settlement, which was rejected by this court, was challenged before this court. From the date of that order, till now properties are sold, sale certificate are registered. There's nothing more remaining for redeeming the property.
That's all, Mr. Ravi
Everything is
Shankar,
over.
he also say.
Lords,
Everything is
now,
absolutely over.
Lords, now
And
everything
sir,
happened.
Sir, let me complete, sir,
Please, please.
Your lordship may kindly come to order dated 23/5/2024. How this court was absolutely misrepresented. 23/5/2024, my lords. This is how the conduct of the petitioner.
23/5.
2024, my lords.
Yes.
Heard learned counsel for the petitioner and appellants and pursued the materials on record. It is submitted due to bona fide reasons and unavoidable circumstances and sufficient cause. Appellants was not in a position to deposit 1 crore within a period of 2 weeks as ordered in 27/9/2023. So after lapse of more than 9 months, this modification IA was filed. by this court. It is submitted that subsequently the appellants are ready to deposit 3 crore 50 with the respondent bank, which is not ready to receive the said amount, nor had entered the appearance in the present petition. And as such, appellants have filed the instant application in the IA number 1 for modification of the earlier order dated 27/9/2023. Because the process to serve summons on me was taken on this date, 23/5. I don't know which senior counsel appeared, my lords. He misrepresented this court, stating that bank is not appearing.
Bank is not.
Your lordship may kindly see, it is submitted subsequently, the appellants are ready to deposit. We are not appearing. No such steps was taken. On that day, steps was taken to serve the summons on me. The order dated 27/9/2023 was not communicated to me. In the midst, they don't serve any copies on us, don't take any process. On 23/5, they come before this court, says that bank is not appearing, they're not accepting my check, and take this order in the vacation bench. Until date, no amount is deposited.
In view of the first fact sufficient on the other that they are ready to deposit it.
Process also I verified in the court, my lords. It was taken on the same day, very same day, 23/5 only process was taken on me. Then I entered and render my appearance. Then I come to know about all these court orders. By that time, everything was over. Sale certificates are registered. My lords, your lordship may kindly.
All sales.
Everything, both properties are sold.
Then
Nothing.
Mr. Ravi Shankar, nothing survives in this. Yes.
Lords, in view of the interim order granted, if they have not presented the check, they cannot have a grievance because the property, I am really not aware as to when the second property is sold because I have the knowledge of that first property is sold. Lords, these are very valuable properties in Ashok Nagar,
These have been sold.
My lords, first property was, sale certificate was executed on 11/12/2023.
11?
Both, I got the copies for the court.
Innೊಂದು ಯಾವತ್ತು?
11/2/23.
Yes, my lords.
11/12.
11/12. As on that day, interim order was not operating.
Both the properties?
Yes, both. I'll just come.
I don't think, Mr. Ravi, so much indulgence has been shown.
Lords, may I just make this request in that event, Lords? Lords may dismiss this red tipple with liberty to approach the DRT to challenge the sale because what is under challenge is.
That would be better, Mr. Ravi Shankar.
I understand, my lords. Now I really, lords, if a check is given to them, if they don't present the check, they come and say that.
But that's being contested by him.
Lords, that's the reason why I'm submitting, my lords. If they present the check, your lords may not examine anything. Your lords may eventually relegate me to the DRT. But let them not make a statement without presenting the check.
We can do one thing. We'll record your submission. You want to withdraw the appeal and go to the DRT with appropriate remedy. That would be better.
And lords may consider, my lords, exempting the period which I have spent before this honorable court.
That goes without saying, Mr. Ravi Shankar.
Lords, what happens without that observation? It becomes difficult for us before the DRT. Lord. That's what practically happens.
Why?
That this is
No,
the problem.
we will record this also. According, we will say so. Mr. Ravi Shankar says he will seek the benefit of 14.
Section 14.
That is for the tribunal to consider. After some hearing, the senior counsel for the appellant seeks to withdraw the appeal to enable the appellant seek such remedy as available in law. And also praying for the benefit of Section 14 of the Limitation Act. The appeal is dismissed as withdrawn. Okay. Thank you. Next.
Lords, the second property was sold on 21/3/24.
Next.
Please.
We have given the date in that.
I'm so sorry, not sir,
No,
that
it's
I
all
was not
right.
able to appear on time, but the memo is ready.
Pardon?
So that I can avail the remedy of review.
Pardon?
A memo, my lord, so that I can avail the remedy of review was.
Yes. So you withdraw this then?
Exactly, my lord, sir. That's a memo so that I didn't want to take it on
Okay,
myself. In the presence of the petitioner, my lords, and the memo bearing his
Very
signature.
well. Just say this. Ma'am, did anyone appear for the other side?
No, nobody.
Nobody. Just say this, ma'am, just inform if someone had come. No one had come now.
Tomorrow.
No, anyone came for the respondent. No.
I shall intimate.
Pardon?
I shall intimate about the memo to the respondent. I shall intimate.
Corrected. Corrected.
Who was the counsel who appeared
Before, for the respondent.
for the respondent?
Mr.
Akash Pawar,
Mr.
KVS.
Yes, Mr. Pawar.
Can you do this? Just call him after lunch. Possible?
I'll make a call.
Okay.
I'll make a call. I'll make a call. I'll make a phone call. I'll make a phone.
Just inform him then.
I'll do the need. I'll
The-
also
the-
transmit a copy.
The learner counsel, just cut that, huh? The learner counsel for the appellant has filed a memo, dated 2/9/2024, which reads as under full stop. From the memo, it is, from the, in view of the contents of the memo, comma, the present appeal is dismissed as withdrawn. To enable the appellant seek the, to enable the appellant file a review petition before the learner single judge. Just say this. Yeah, just say this. We'll say this. In view of the contents of the memo, the appeal is dismissed as withdrawn. That's why we'll say.
With that liberty to review there. With that
To
liberty for
enable,
review.
to enable the appellant approach the learner single judge
For review.
by way of a review petition.
And if possible, minutes at section.
Yeah,
14.
with liberty to the with liberty to the appellant to approach the learner single judge in accordance with law.
For a review. And minutes, only one request, minutes. We keep making this, I'm sorry, but it's that section 14. So that
It goes without. Tell us what.
all right.
And my view is very consistent
Please, minutes, please.
that when 14 exists in the statute books,
I don't
every-
need to seek for it. I
you
will.
have to only seek it there.
I do not, yes.
See, who will consider 14? That
Of
bench.
course that.
Who is granting the benefit of 14? It will
Very
be
well,
them.
very well, very well, very well.
Thank you.
Great.
We'll come back after lunch.
ಊರ್ದೆಲ್ಲ ಹಬ್ಬ ನಿಮಗೆ, ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಕರೀತಾರೆ.
ಭಯ ರಜತ ಅವರೇ ಹೇಳ್ಬಿಡ್ತಾರೆ ಅದೇ ಯಾವಾಗ ನಂಗೆ ಬೇಕು ಅಂತ. ಒಳಗಡೆ ಹೋಗಿ ನಕ್ಕು ಬಿಟ್ರೆ ಇವತ್ತು ಅಷ್ಟೇನ್ರಿ ನಾನು ಬರಲ್ಲ.
ಹಿಂಗಾಗಿದೆ ನಂದು ನಾನ್ ಬಂದ್ರೆ ಒಂದು ಆಪ್ಷನ್ ಅದು ನೋಡ್ತಾರೆ ಇವತ್ತು ಬಂದಿಲ್ಲ ಎಂದು ಆಮೇಲೆ ಮಾಡ್ಕೊಬಿಟ್ಟು ಹೊರಗಡೆ ಬಂದಿಲ್ಲ ಕೇಳಿದ್ರ
Yes.
Serial number 32, property matter.
So Naganand engagement is on the way. I request for a 5-minute pass.
We have passed over. We have again called. Let him come. He argued for some time
Argued for some time.
that solar panels,
This matter pertains to that
that,
cancellation.
what is this?
Cancellation of the PPAs, my lords, by the government. Single judge has passed an order in favor of the petitioners for the respondents before this court. So it's a matter which has been covered by the judgment, my lords, by the other case, my lords, this honorable court, which is affirmed in the Supreme Court as well. The Aman Raju's case, my lords. So the very same facts and circumstances, my lords. So the cancellation order, my lords, which was based earlier, my lords, it is based on a circular which was passed subsequent to the PPAs, my lords. So this honorable court, my lords, in the other decisions, my lords, has held that application, those cancellations which is based on a circular which is passed subsequent to the agreements, which is not applicable, my lords, which has been affirmed in the honorable Supreme Court as well. So this is the crux of the matter. Only thing which the contention they were taking was that, my lords, 9.56 is the rate, my lords, per unit. So now the present rate is around 3 or 4 rupees, my lords. So that should be based on which. Sorry.
So what are you are for?
I am for the, my lord, the original,
respondents.
Respondents, original petitioners, my lord.
You can start. Let him, he will join you.
I've already given a list of dates and submission.
Should I keep your lordships, my lord, engaged by saying something? Because to keep your lordships, my lord. My lord,
Yeah.
I filed a list of dates and synopsis, my lord. Petitioners and the respondents, correct.
Yes.
Lord, on 22/5/2014, government came up with a solar policy, my lord. Which, my lord, what has happened is, my lords are, my lord, it's like carrying coal to Newcastle. Today, my lord, with the global warming, the coal, my lord, generates, my lord, a lot of carbon emission. Therefore, my lord, green energy is what is, my lord, to be, my lord, encouraged. Even the 2013, my lord, the Electricity Act itself, my lord, mandates that my lord, they have to be, my lord, renewable energy, my lord, is to be encouraged. So, my lord, the government came up with the policy. And, my lord, in the background of that, my lord, solar, my lord, there are a lot of potential areas, my lord, in Karnataka. Therefore, my lord, this policy, my lord, came about. In furtherance of that policy, my lord, they came up with a circular, my lord, which is at page 522, their paper book, which, my lord, mandates that, my lord, persons who want, my lord, set up solar panels on the rooftop, they are, my lord, permitted to file applications and enter into a power purchase agreement. In furtherance of that, my lord, on 19/2/2016, petitioners entered into, my lord, a power purchase agreement, serial number 3. PPA, my lord, has been, my lord, it was to be enforced for 25 years. What they do is, my lord, that PPA is also, my lord, approved by the Karnataka Electricity Regulatory Commission. Serial number 4, my lord, is where I have, my lord, set that. Thereafter, my lord, BESCOMs issues letters to the respondent granting approval for installation on the rooftop panel. They have also indicated the methodology for purchase, all that, my lord, was there. We, my lord, went ahead. We cut, my lord, our trees because we had to put up, my lord, those panels, all that. At that time, my lord, BESCOM started harassing the petitioners. They, my lord, started issuing
No,
notice.
what is this cutting various fruit yielding trees? Was it not on the rooftop?
My lord, what has happened is we had to put up a, my lord, a building. For that building, for that purpose, my lord, in some land, my lord, only for that limited purpose, my lord, we cut. Anyway, that may not be of much relevance, but then, my lord, that is what, my lord, is mentioned in the petition, so I'm, my lord, mentioning it. But what they did was, after, my lord, entering into a power purchase agreement, after, my lord, getting the same, my lord, approved by the KERC, they started sending police. They have, my lord, BESCOM has also, my lord, all these the governmental companies or corporations have, my lord, some police wing. So, police wing, my lord. They started sending the police. Resulting in, my lord, police notices were issued. My lord, we have put that also, my lord, at page 181 to 210. Notices were issued. Ultimately, my lord, they cancelled the PPA, serial number 7. PPA was valid for 15 years, 25 years. They have no power, my lord, of cancellation. They cancelled it. We challenged it before your lordships in a writ petition, my lord, in WP 52694 of 2016. Your lordships, my lord, allowed that writ petition. Quashed, my lord, the order cancelling my power purchase agreement. And, my lord, thereafter, my lord, they issued a show cause notice. One more, my lord, final order of cancelling was passed, serial number 10. That was again, my lord, challenged by us before your lordships. That again, my lord, was set aside. Ultimately, my lord, the fourth, my lord, the third time, my lord, they have cancelled, and we are before your lordships. Under almost similar set, my lord, their contention is threefold. One, that, my lord, the power purchase agreement was valid for a particular period. We had to put up, my lord, the rooftop panels, my lord, within a particular period. We could not do it, my lord, because, my lord, they went on cancelling. We have to come before your lordships. Time and again. Therefore, my lord, a person who is that, my lord, he can't, my lord, hold out his own act, my lord, to give him, my lord, some advantage. Any number of judgments are there of your lordships also. Under almost similar set of circumstances, my lord, some other persons also, my lord, came before your lordships. Your lordships, my lord, allowed the writ petitions. Writ appeals filed, my lord, dismissed. SLP files dismissed. Today, my lord, their contention is that one, that, my lord, there is an alternative remedy. My submission to your lordships is all those other persons, my lord, there is a saying in Kannada, my lord. It's like one kandik bende, innond kandik sunna. That is, my lord, lime for, my lord, lime is, my lord, very, not, my lord, lime juice. This is the chunnam, my lord. Lime for one and, my lord, butter for the other. It can't be. They, my lord, raise this very contention, my lord, before the Supreme Court also alternative remedy. My lord, Supreme Court, my lord, dismissed the SLPs. Ultimately, my lord, they are bound by, my lord, the orders that have been passed. Their contention, my lord, in all those cases, 6 months time were granted, my lord, by this honorable court, saying that from the date to the order, you are granted 6 months time. Here also, my lord, the similar order was passed. They challenged it before your lord.
6 months for what?
From the date, my lord, for completion of the entire process.
But that stage has not, generation stage has not reached.
My lord, generation, my lord, I have to, my lord, set up the panels.
That's what?
They cancelled, my lord, even before, my lord, I could procure all that, my lord, where I placed orders. Before it could come, my lord, they cancelled everything. Came before your lordships. Your lordship set it aside. Second order, set aside. Again, my lord, we came before your lordship.
You say that previous orders of setting or quashing it, or the PPA which was, so that resulted in you could not able to establish.
Absolutely, my lord. That's, my lord, any number of judgments are there that, my lord, the act of a person, my lord, can't result in, my lord, a boon for himself. Here, they, my lord, cancel my PPA. Resulting position is that, my lord, I have come before lords because I can't, my lord, set up, because if I set it up, I will not, my lord, be able to generate, and, my lord, I will not be able to, my lord, put it into the grid. This is the situation where I was. If I can tell you, my lord, request your lordship, just look at, my lord, 4 judgments, my lord, which are part of the compilation itself. earlier judgments passed, my lord, by the division benches, single judge, division bench and the SLPs, my lord. Page 553, serial number, my lord, 11, my lord, in the second unnumbered paragraph, I have, my lord, referred to them. Gulbarga, my lord, the division bench has directed that, my lord, it passed an order, PPA cancellation was set aside, and, my lord, this honorable court directed that within 6 months you set it up.
In the earlier round of litigation.
Yes, my lord. No, those were, my lord, they have to become final. That is somebody else's. Mine also, my lord, they said the same
That
thing.
6 months has been challenged there.
No, my lord, they challenged it before the Supreme Court. SLP dismissed. Therefore, in the light of that, my lord, my submission to your lordship is, my lord, that's why I said there can't be, my lord, discrimination in Article 14 between, my lord, two persons. They, my lord, go right up to the Supreme Court. Today, my lord, their contention is, oh, there is an alternative remedy. My lord, my submission is, once, my lord, a petition is admitted, question of alternative remedy would not arise. One. Second, their contention is, KRC has now come up with some policy. My lord, it's like, my lord, going to, my lord, the challenging, my lord, Caesar's orders before the Caesar's wife, as they say. I can't go before the KRC, my lord, the matter is pending before your lordships. Your lordships have allowed the petition. Now at this stage, my lord, they can't raise the plea of alternative remedy. Because once, my lord, the petition is admitted, courts have time and again held that, my lord, alternative remedy is not a bar. At any rate, there are enough, sorry, my lord, my learned friend has come. Enough judgments of your
Nagaran,
lordships.
you can start. He was just.
I'm sorry, keeping the court busy because they were just keeping quiet and I felt very, very bad, my lord.
It's all right.
My apologies.
Oh, it's all right.
Not the.
You have those list of dates also, no?
Yes,
Mr.
my lord. What my learned friend has given, I have that. Yes. Lord, I would like to not formulate a proposition. First proposition, my lord, is whether in a repetition, such relief can be granted when the real remedy lies before a special forum, which is the Electricity Regulatory Commission. This is a dispute between a generating company and a distributor. That squarely comes within Section 86, and whether the learned single judge was justified in not considering that objection. The second submission, my lord, I have is this. The dispute arises under a contract. That is the power purchase agreement. And the contract has been terminated. And according to us, it has been terminated justifiably on facts which I will presently show. Whether the writ court can entertain a challenge, set aside the termination, and practically give specific performance of a contract for supply of energy.
This PPA had come into effect?
Yes.
On the date of execution?
Yes, my lord. PPA had come into force. The procedure, my lord, is that the PPA has to go before the Electricity Regulatory Commission for its approval. It went before them. They've granted the approval also. So the validity of the termination and the consequences of setting aside the termination is practically a direction is given to us to purchase power from them and pay them at a price which is far in excess of what the current price is. That's another facet of the case.
What has been agreed or what is?
What is agreed? The PPA contains an agreement. PPA contains a price of 9 rupees 56 paise per unit. And that 9 rupees 56 paise was determined on a certain basis. And that basis has now changed. And I'll draw attention, my lord, to the orders of the Electricity Regulatory Commission, which progressively noticed the price has come down. And admitted position is on the date of termination, they had not placed any order for equipment. They had not put up a building. They had not purchased the generators. They had not installed the solar generators. They had not done anything in the matter, except according to them, they had cleared the land of some trees that were there and shrubs. That's the stage.
Was there any scheduled prescribed under the PPA?
Yes, there was a schedule.
Timelines.
Yes, 1 year was the schedule. Within 1 year, they must complete it. Now, my lord, what happened was, this is not the first time the matter has come before the Honorable Court. Earlier occasions it has come. That is the main plank of the case of the other side. They say others have been given that relief, so why I should not get that relief? That seems to be the main case. Lord, in the earlier case, what happened was, there was initially, my lord, the period was 1 year for them. That was changed by a subsequent circular making it 6 months. So the generators contended that we have taken steps, we have started the installation process, we are at an advanced stage of construction, building is built, only generators have to be installed. At this stage, if they change the policy and make it 6 months instead of 1 year, it's unfair. Therefore, my lord, this honorable court took the contention that you can't change midway after you've entered into, principles of estoppel will apply. And therefore, their lordship, my lord, said this termination is not permitted. And you are now directed to give them 6 months' time, which was originally envisaged. That's how, my lord, that litigation went. But in the current case, my lord, what has happened, the facts are slightly different, my lord. If your lordship doesn't mind, my lord, taking writ appeal 1274, volume 1, the submission I am making, my lord, is that there was full justification for termination of this power purchase agreement. And I will make that good. The
Which page?
in volume 1, annexure B, I'll give your lordship the page number, my lord. So volume 2 of the column. Volume 2, my lord, I'm sorry. Kindly take volume 2, my lord. (523), that is the circular, my lord, relating to, there is a English version. No. Not what has happened is, my lord, the papers are.
Request to everyone, possibly, you can tell the briefing council to paginate your briefs from this.
We have the same pagination. We have one.
Just give us the running page, Mr. Nagan.
Yeah, no, my lord, the reason why I'm little, my lord, difficulty is this. What has happened is, number of documents, my lord, are in Kannada. So what we have done is, we have filed, my lord, a separate memo containing 2 volumes, which contain the same documents which are in Kannada, but typed and translated also. There is an office objection regarding that. But your lordship, my lord, will find all the documents in this volume. This is, my lord, is
Refer to
this volume, yes. Page 21.
The second one.
In volume 1, my lord, of this 2-volume compilation.
Which page you said? 21.
Page 21, my lord.
Volume 2. Volume 1.
Let me get the page numbers. Pencil mark, correct.
Yes.
This is, my lord, the 10/12/2015. The solar policy, my lord, is of the year 2014. I don't have to trouble your lordships with the details of that. Then, my lord, is this circular. Encouraging installation of solar panels on top of buildings. As per Solar Policy 12/21, in a move towards encouraging production of solar energy, ESCOMs will soon invite applications from customers to install solar panels with net metering on top of buildings. A specified amount as fixed by the KPTCL will be paid for the power produced during these rooftop solar panels. In case of new buildings, installation of solar panels on top of buildings will be encouraged. It will also be helpful for installation as per architecture of the building, and installation will also be easier. In this background, the customers can also submit application for installation of solar panels on top of buildings while submitting application for construction of new building. The power purchase agreement shall be made as per the present KERC rates. This power purchase agreement will be valid for a period of 1 year. The construction of the building should be completed within a year and power supply should be obtained. In other case, the price of power will be fixed as per KERC rates that will be applicable on the date. Now, my lord, this was withdrawn on 28/3/2016. That, my lord, is something is not in this compilation. It was filed later, my lord, the memo. There's an IA, my lord, that is filed IA number 2 of 23. In that it is produced as R7.
What is the date of that?
The date, my lord, is 28/3/2016.
28th of March.
This is issued by the BESCOM. Now, the government took this decision on 22/3/16, which was followed by the circular from the the distribution company BESCOM. If your lordship has, my lord, the IA number 2 of 23, the English translation, my lord, of the government order and all the other English documents are there. The papers are, my lord, quite messy in this case. Normally what would happen, my lord, writ appeal papers will contain everything. Your lordships will not have to refer to any other volume. But in this case, because of this confusion about the English and the translations, because large number of documents are all in Kannada. Or ಸಿಗ್ತಾ ಇಲ್ಲ. Green.
They filed petitions in 2017.
Yes, my lord, 2017. Not the, I may not till instead of wasting time on this, my lord, I'll proceed and come back to this, my lord, little later. Now, my lord, if your lordship should go to the power purchase, I will not trouble your lordship with applications, my lord. Kindly go in the same 2 volumes, my lord, to page 113. This is the power purchase agreement. My lord, similar agreement, there are along, my lord, several petitioners were there before the court, 6 of them. I'll show you lordship one sequence, rest of it are identical. Annexure J, page 113.
Yes.
This is a power purchase agreement for solar rooftop plants. Your lordships may see the recitals, my lord. This power purchase agreement entered into at so-and-so between Bangalore Electric Supply Company and then Veeraya. He is the petitioner, first petitioner in this case. The seller intends, whereas the seller intends to connect and operate solar rooftop photovoltaic system with ESCOM's HTLT distribution system for sale of solar power to ESCOM in terms of Electricity Regulatory Commission order dated 10/10/2013 as amended from time to time. So the entire agreement is on the premise of the rates and the approvals given by Electricity Regulatory Commission. And the system was a rooftop system which they had to build. Then seller intends to install and has installed solar rooftop system of 1000 kWp capacity on the rooftop of the premises situated at Venkatapura, Pavagada Taluk, Tumkur district and connected to Electricity Supply Service Commission bearing number RR number so-and-so in the same premises under so-and-so division. Now, in that RR number, your lordships will notice no RR number is given, but it says site under construction. So on the date of this power purchase agreement, they had not obtained a regular power supply connection. If they had obtained a supply, they would have had an RR number. The whole object of this policy, my lord, is that if I own a building or a house or an industrial building, I can put up a rooftop generating plant on top of the roof of that plant, of that building. It was not meant to be a standalone generating company generating solar power by installing panels anywhere on the ground or anything else. That was not the intention at all. Intention was on top of your building. And on top of your building, meaning that you should be a consumer. You will consume the power which you are generating.
Captive use.
And thereafter, you can distribute. So, my lord, if they generate, say, 1,000 units a day, they may consume 300. The remaining 700 will go to the grid. So, there's a two-way metering system. So, at the end of the month, they will check how many units you have generated, how much you have consumed, deduct that. For the balance, the distribution company will pay you money at this agreed rate. That was the whole scheme. And the scheme was to encourage people to use their rooftops for this purpose. And my lord, it also talked of a promotional tariff, because at that stage, they wanted, my lord, this system to become somewhat popular. If your lordships would go to page 117, clause number 6, tariff. A, BESCOM shall pay for net metered energy at 9.56 per kilowatt hour as determined by KERC for the term of the agreement.
This rate has been fixed by KERC.
KERC has fixed the rate. My lord, this was fixed on 10/10/2013. And your lordships will find that, my lord, as annexure K in the same volume.
Which page is that?
I'll give you lordships the page. 177. Please see how they determine the rate, my lord. First para is about the need for this. Section 86 mandates promotion of cogeneration, generation of electricity from renewable sources of energy by providing suitable measures for connectivity with the grid. Then next paragraph. Commissioned by its tariff order of 13 July 10, a determined tariff for grid-connected photovoltaic solar thermal power plants and rooftop solar photovoltaic and other small power plants. Tariff determined in this order was valid for projects commissioned up to 31st March 2013. This is prior to the current one, madam. Earlier, they are recalling what had happened in the past. Then, my lord, the number of paragraphs relate to the public notice for fixation, etc. Then page 178, bottom, para 3. Determination of tariff. Life of the plant. The Commission has proposed to consider the useful life of the solar photovoltaic thermal plants for 25 years for the purpose of determination of tariff. Messrs. So-and-so, BESCOM, so-and-so, so-and-so have agreed with the assumption of useful life for 25 years. Messrs. Terry has suggested that the performance of this thin film modules gradually drops with age, and hence a performance warranty of 90% of the rated power in the first 10 years, more than 80% subsequent 15 years has to be assured by manufacturers, developers. Mrs. Atria Power has suggested to consider 1% of the capital cost every 4 years towards overhauling expenditure of thermal plants. I'm not troubling a lot with the rest of it. What I'm saying is, how they went about with it is they took all the technical parameters. What is going to be the life of this plant? How many years it will take for it to be installed? What is going to be the running cost? And finally, my lord, they took note of capacity utilization factor. And at page 181, they came and arrived at what is the capital cost. Because the generator, my lord, if he puts his money, puts up a plant, he should get a return on whatever he has invested. Paragraph D at 181. The following were the capital cost norms proposed in the discussion paper. Solar PV plants 9.40 crores to 10 crores per megawatt. Thermal plants, rooftop plants, 0.80 lakhs to 0.90 lakhs per kilowatt.
Thermal, solar thermal plants.
Yes. Solar and thermal, that is, my lord, it's a kind of a hybrid.
It's not one word, solar thermal plants.
No.
Solar and
And
thermal.
it would be solar hyphen thermal, yes. Like now we have many cars, my lord, they run on electric and petrol both. So they are hybrids. Then, my lord, they look into the details. Various parameters are all taken note of. Interest, what is the operational maintenance cost, working capital, return on equity, metering. And at page 193, they make a table of various factors which they take into consideration. And at 194, they approve the rate. Paragraph 5. Tariff for grid-connected solar PV, solar thermal power plants, and rooftop solar voltaic plants. On the basis of approved parameters, the following is the approved tariff. Third one is what we are concerned with. Rooftop and small solar PV plants, 9 rupees 56 paise per unit. Then, my lord, this goes, the agreement goes before at to KERC for approval. At 204, they grant approval.
It is not the KERC decision 194.
194 is KERC decision.
So why?
That's a tariff order.
No, again.
Lord, this tariff order is a generic one which relates not for individual case. They look at the whole sector. For this sector, what should be the tariff?
The broad.
Yes.
The policy.
The policy coupled with an actual determination. Because pursuant to this policy, if I am an entrepreneur and I have seen this order and I say, well, I want to set up a plant, then I know that I'm going to get 9 rupees and not. So I make a proposal. And if I comply with all the requirements, then a formal power purchase agreement is entered into. That formal power purchase agreement, my lord, up to a certain capacity, there's no need to go back to KERC for approval if it conforms to this tariff. If the capacity is higher, then it has to go back to KERC for approval of the individual PPA. In this case, that is what has happened. If your lordships could now please turn to page 204. The type copy is at 205. In terms of this policy, the power purchase agreement was entered into, my lord, on 19th of February 2016. Page 113. Just now, my lord, your lordships were pleased to peruse them. Page 205, 13th of April 2016. From Commission to the Managing Director of BESCOM, purchase agreement in respect of Veeraya. I am directed by the Commission to communicate approval of the Commission the power purchase agreement. The STR PV system shall be designed, engineered, constructed, commissioned, and operated by the seller or any other person on his behalf within 19/2/2017. And this is also copied to the entrepreneur. Then, Lord, what happens is, after this, the BESCOM, Lord, considers it at page 218. And says work can now commence. The type copy, my lord, is at 220. Number of technical requirements are there. You must have an energy meter. Lord, after this, what happens is we conduct an inspection on 24/8/2016.
Inspection of
24/8/2016. Just before that, my lord, at page 253, my lord, there was a large scale manipulations that was taking place in this area in Pavagada. Large number of people, my lord, made these applications, which according to the BESCOM, they were never intended to be rooftop at all. And they simply, my lord, made applications and entered into PPAs when they knew there was no building or anything. So, my lord, there was an investigation by the police, as a result of which, my lord, at annexure P 253, type copy is at 253, my lord, is one such notice. This is dated 20th of August 2016. This is to inform you that you have entered into an agreement with BESCOM on 19/2/16 regarding generation of solar energy. On verification of PPA and physical conditions at your site, it is noticed that you have violated following conditions. You have signed PPA for either non-existing buildings or construction is not started. You have entered PPAs for structures without RR numbers. You have entered and signed PPA for solar RTP generation against RR numbers of IP sets. RR, my lord, is a consumer number. Each installation will have a consumer number. That means he is enlisted, he has a certain sanctioned load, and he has to pay the minimum and also the energy charges.
So he is already a consumer.
Exactly. The rooftop scheme was, I'm a consumer, I have taken supply, now I want to install rooftop so that I will lessen the burden on the distribution system. I will generate to the extent I can. And to the extent I consume, I will use it. Rest I will give it to you. That's the scheme, that's the policy also. Then, my lord, they raised a number of issues. After this, there is a inspection, my lord, that takes place on 24/8/16.
Yes.
One day after that inspection, this reply at 2:54 comes. Each point, my lord, they meet. First point at 2:54, you assign PPS for non-existing buildings. For that, he says that I have to construct the building. I have clearly mentioned in my undertaking, the solar plants will be installed on the roof of the shed that we are going to be constructed.
What is the schedule for construction and what is the total duration of PPA?
Duration of PPA is 25 years. And schedule was 1 year was the time limit for him to.
The date of PPA.
Yes, from the date of. Then, my lord, next page at 2:55, he is explaining each of these structures.
Now let's assume for a moment in the case of this gentleman, What was the date of PPA?
PPA is 19th February 2016. So we are 6 months down the line and notice is given saying nothing has happened. And the allegation is that you have represented that there's a building, there's no building. There was a RR number which has to be there, it's not there. In some case, my lord, if there's no building, there's no RR number at all. If you have an agricultural pump set, they give it a separate IP number. That IP number is not eligible in the scheme. Suppose, my lord, I have a farm and I have one borewell there. And I take an IP number for that, for supply. And I pay them at IP rate.
But the PPA does not depict RR number when you are executing PPA.
It's not, in this case, it is not. That's why I pointed out. It says not yet obtained. The admitted position is they have not put up the building and they have not applied for permission.
In cases where there is no building, there is no RR.
No RR, because there is no building.
Sorry. Yes. But that position or that situation is also contemplated under your scheme?
No, in our scheme, my lord, the scheme contemplates that you will put up a plant above a roof. So you must be a registered consumer with an RR number. So these people applied without that RR number and without the building.
Then why a PPA with them?
Our PPA, my lord, is at the initial stage to say that if you generate power in accordance with this policy, we will purchase from you.
No, but that presupposes, now, Mr. Narayanan, there is an RR number, he is a consumer, you are entering into PPA for the balance which he will not use it.
Yeah.
Okay. But why a PPA where there are no RR numbers?
No. My lord, in the earlier scheme, my lord, if your lordship could see the circular of 10, 12, 15, just now which your lordship perused, annexure B.
That's at page 21.
Yes. Point number 4, my lord.
Yes.
Page 21. In this background, customers can also submit application for installation of solar panels on top of buildings while submitting applications for construction of new building. So before the actual construction, when you submit an application from the local authority for any permissions, at that stage also, you can submit an application.
So there won't be any RR.
There won't be RR at that stage. Now, my lord, if they strictly follow this, then they will get 1 year. That next para, my lord, refers to that. Now, when this 1 year was curtailed,
this power purchase agreement will be valid for 1 year.
Yeah, that is, this means what they mean is the power purchase agreement which will be entered according to this, because this is a circular giving effect to the policy.
Because this is only basically, creating an infrastructure for 1 year, within 1 year.
Exactly.
It would be for 25
years. That means that the power purchase agreement will be valid for a period of 1 year, means that is for the purpose of completing the work. That was sought to be curtailed to 6 months. That was the subject matter of the other case, my lord, which
sought to be curtailed by 6 months.
Yes, instead of 1 year, the government said we'll withdraw this and make it 6 months. Your lordships are seeing the reply, annexure P, my lord, at page 253.
That's the police.
Sorry, my lord. P50, 54 is the reply, my lord.
Sir.
Kindly go to page 255, my lord.
My lord, I'll come back in 5 minutes.
Reply, you have entered signed PPAs for structures without RR numbers. That was one point which was made in the police notice. To that he says, while submitting my application, I have not mentioned any RR number, but it is stated that the RR number is going to obtain only after completion of construction of the shed. In this context, I was also clarified by the departmental officer that RR number is going to be given and allotted only after completion of construction of shed, but not in advance for construction of shed. That is correct. Then, but the one more fact now may not is admitted position, no shed is constructed. The answer the other side is, I would have done whatever I was supposed to do. You gave me all this trouble, gave me one notice, then I had to reply. Then you gave me one show cause notice. I replied to that. Then you terminated the power purchase agreement. Then I came to court. Honorable court granted an order setting aside that and said, you please re-examine after giving notice. Because of this, I didn't do anything. That's their answer. Now, to that, my lord, the court never gave any order to say you should not do what you're supposed to do, but I'll show the time frames, my lord, what happened in this time frame. So this was the type of reply that they gave. Then please then go, my lord, to the show cause notice, which was given, annexure Q at page 283. This should be in the second volume. English version. The English version, my lord, is at page number 296. This is, my lord, in August of 2016, after the inspection. Between February and August, the only impediment, if you may call that, is a notice from the police 6 months after the PPA is entered into. That was in August 20th of August.
By which order you reduced the period from 1 year to 6 months?
It is there in the IA for
That's annexure 7, you have said R7.
Yes.
Okay, that we will see.
R7, which is page 6, my lord.
Of that IA.
There's an affidavit for production of additional documents, IA2. In that, my lord, at 7. What they did was, they withdrew the earlier notification.
That you reduced to 6 months.
6 months.
What is the date? 28/3/16.
28/3/16. First, government issued, my lord, 2 days earlier, and the order is, my lord, at 22/3, government order R7. Following that direction, KERC, the electricity company, replied, sent this. So 6 months have gone by. After one explanation police sought, then, my lord, comes this show cause notice. That's at page 296.
So cause before cancellation.
Yes. This is, I would call it the first round, my lord. He raises, my lord, 3 points are raised in this. As per rules, I'm reading the last sentence of first paragraph. As per rules of the solar power generation,
Yes.
atop buildings, there are certain rules which are as follows. Photos.
Yes, one minute, sir. Yes.
Land on which the buildings will be constructed should have been converted. The documents of land conversion should be produced, which is not followed. There is no approval letter from KERC to generate solar power atop the building. No works have been commenced to establish solar power generating unit atop the building till date. Hence, your notice is sent to you questioning why power purchase agreement to establish the solar power generating unit atop the building should not be cancelled. You are asked to contact the office within 3 days with your objections. Page 297, my lord, is their reply. Explanation, question 1 here. Bottom of 297. As you have mentioned in reference to We have entered into power purchase agreement with Bescom purchase power generated. While submitting application, we had mentioned that the land where the proposed building will be constructed will be used for dairy farming, sheep farming, etc. No objection certificate is issued on 17/2/16 along with signature from Venkatapura Gram Panchayat relating to this matter. Based on this, a spot inspection is also conducted from your office and all documents were verified thoroughly, certified stating that all documents are correct. Only after that we entered into a power purchase agreement with you. As mentioned earlier, the purpose of constructing building is for dairy farming, sheep farming. As these activities are agriculture related activities, there is no need for land conversion. In case it is legally compulsory, we are committed to make necessary arrangements for the land conversion to establish solar unit within the stipulated time. So building not envisaged, they're going to put up a sheep farm is what they're now saying. Then the next point is, my lord, that for generation on top of a rooftop, a power purchase agreement has been made with Bescom and your office on 19/2 for purchase of power. Application documents concerning the verified power purchase has been submitted to higher authorities through Office of Executive Engineer. Higher authorities, after verifying, have submitted same for approval of KERC, where once again all documents submitted, examined, and approval is given. KERC has instructed to establish power generating unit within 19/2/17. That's what your lordship saw. Xerox copy of the approval is given. In the meantime, based on approval letter of Executive Engineer, he has issued commencement certificate on 11/5/16, issuing orders to complete construction on 19/2/17. That's extracted as follows. So second point, the answer, you say we have got permission. Then third point, no work has been commenced to establish solar power plant atop a unit of building. As mentioned above, to establish solar power generating unit top building, we have already undertaken cleaning of land, drilling of bore wells, cutting of trees, bushes, fencing of land, leveling of land, designing of plant, arranging of funds, identifying investors, etc. As mentioned, survey number. In the meanwhile, department officials are visiting the place in the name of investigation verification, frequently are asking irrelevant questions and troubling us. They are forcing us to return the PPA to department. Bescom Vigilance also issued a police notice. We hereby submit that we have already given suitable reply. Once again, now we have to issue show cause notice, creating confusion. Process of establishing solar power generating unit is delayed a little. However, we herewith clarify we are committed to establish solar power generation within the date given. Then, my lord, the decision is taken to terminate it. Your lordship should get it in annexure R 415.
Tell us, Mr.
There-
Naganan,
Yes.
if they don't comply, is there any obligation on your part?
Yes, my lord, we are obligation on our part means
Or what is the obligation on you?
the obligation on us, my lord, is we have, my lord, under the MNRE guidelines, we are required to use a certain percentage of our generation. We have to mandatorily convert it into eco-friendly generation like solar and others. So we have obligation to fulfill that. That's why this time limit is given. My lord, if they come to us to say, I want to install power generating plant of 5 megawatts. So we have commitments. These are governed by orders passed by the Electricity Regulatory Commission also and policy of a Ministry of Non-Renewable Energy, Government of India. Now, both those, we plan our procurements from these sources because if I don't do it, there are penal obligations.
Meet your quota.
My quota, I have to meet from that.
What is the consequence?
If I don't meet the quota, my lord, there is a penal provision that is applicable if any industry, any distributor doesn't meet it. So we have time schedules for this because otherwise, if you don't have time schedules, it's never going to finish in time. Page 418 is the first determination. Two things that they notice there. I'll only read the second paragraph. It's a very cryptic order, I agree. No sign, this is the order termination, first order termination. last sentence of first para, my lord, it says, no sign of work to commence established power generation unit atop a building was found. And your lordships will see in item number 7 in reference, there is an inspection on 25/8/16. And what they're referring to is on that inspection, no action was found. However, officials who visited the spot and made the spot inspection have declared that the solar panels installed on the ground or on the roof constructed on steel, iron, wooden, concrete pillars shall not be considered as a rooftop solar power generating unit. And I mentioned that it is violation of rule mentioned at reference number 5 above. Hence, PPA to establish solar power plant atop the building is withdrawn with immediate effect. Now, this was an endemic problem that many people wanted to put up on top of a building, and they got these approvals. And then instead of doing that, they'll just put up a cow shed or some sheep rearing shed or a chicken rearing shed. And on top of that, they wanted to do it. So that
will that make any difference?
Yes, the policy, my lord, is that is not permissible. The whole scheme and the benefit that is sought to be given, my lord, this was an incentivized scheme that was given. It was so that nobody will incur a huge, because my lord, if a generator comes today on a greenfield project and says, I want to set up 5 megawatt plant, then in determining the tariff for that plant, land cost is taken, construction of building cost is taken, equipment is taken, and thereafter the tariff is determined in a two-part tariff. Two-part tariff is, one is a fixed charge, another is a variable charge. Now this is how, my lord, it works. Now in this incentivized scheme, none of these parameters of cost of land, cost of building, none of them are to be taken note of. All that has to be taken note of is you already have land, you already have a building, we are not to amortize that. We are only to take note of the capital cost of the equipment that you are going to put. That's how the tariff determination has been done. They are not taken land cost. Otherwise, in normal course, if it's a big generating company, a thermal power plant, they'll take land, they'll take building, they'll take structures, everything into account.
But your scheme also contemplates construction of a building also.
Yes, my lord, the whole thing is on top of existing roof of a consumer.
That construction is not considered while determining the power tariff?
No, cost of the land and building is not taken into consideration, your lordship.
That is at his cost.
Yes, that is his cost, because the whole scheme is you already have. So you're not building anything for me, for the generation plant.
But it contemplates construction of a building also.
It should, yes, it contemplates, not that it contemplates that this person who comes forward has a building, he is a consumer, and he wants to use the rooftop for generation of green power.
That's the normal, but your scheme also contemplates, there are no RR numbers, there is a construction to be taken.
All through, my lord, the process is that this is only meant for people who are consumers themselves. They should to be consumed. I can understand, Lord. Supposing a building is under construction, roof is laid, everything is done, finishing work is going on. And at that stage, till then I take temporary power, because temporary power is for construction, welding, this, that. That's a fixed amount. Once it reaches a stage when wiring is complete, electrical inspection takes place, then I go and make an application for a permanent power supply connection. Then they give me an RR number. That's the point of time when I become a regular consumer. Once I become a regular consumer, the scheme contemplates that for regular consumers, you can have a rooftop. But as your lordship saw, they contemplated that if you are building and it's not yet over, and it's at that stage you want to apply, we'll still entertain your application. We'll receive the application. That is how the scheme was meant to work. So the only ground, my lord, they say now is in August of 2016, no building is there. My lord, this was challenged on several grounds, and the learned single judge, my lord, at page 443, allowed the writ petition on the ground that they were not heard. At page 449, my lord, I will not trouble your lordships with the entire background. 449, para 7. In that view, these petitions, also the notice of cancellation issued to petitioners and assail in the writ petition stand quashed. Liberty is reserved to respondents to issue show cause notice, a fresh, secure reply from petitioners. Thereafter, pass appropriate orders, take a decision. To enable such consideration to be made, a time frame is fixed, 2 weeks, etc., reply. Then not para 9. It is further, page 450. It is further made clear that though the order of termination is set aside at this point in time to enable the principles of natural justice to be complied, the same shall not give a right to petitioners to commence the work so as to complete the project in the meanwhile and claim equity. In that circumstance, if petitioners undertake any further work relating to project for its completion from this date onwards, till the process of providing opportunity is completed, whether such progress should be taken into consideration or not is a matter left open to be considered by the respondents, but the petitioners shall not be entitled to claim any equity in that regard, unless the respondents choose to consider and accept the same to treat the project as completed. Further, while considering the explanation of petitioners, if any need arises for altering the terms of the agreement, that's important. That is also a matter left open to respondents to take note of the same, take a decision in accordance with law. After the decision is taken by respondents, if petitioners are still agreed with the action, liberty is left to the petitioners to avail remedy in accordance with law. So by the time this order was passed, there was some developments more. That's the reason why this observation is made, because the KERC, my lord, in the interregnum, passed another tariff order on 2/5/16. And in that tariff order, they determined the rate at 5 rupee 20 paise, down from 9 rupees 56 paise
per unit.
The reason why it came down, the tariff order is also placed, my lord. It's along with my statement of objections. It is annexure R1. I'll presently show, my lord, there are 4 tariff orders. I'll show them in one stretch, my lord. I've just given the date. So that's the reason by 2017, when this order was made, the learned judge, my lord, took note of that fact and said that if it has to be changed because of the delay in doing anything that they were supposed to do, that will be taken. It will be taken into consideration. On the very first day, I made a submission, my lord, if they're willing to do the project now, and they're willing to take the tariff rate, which is currently fixed at 3 rupees 20 paise, I am willing to continue, take supply from them. But they now are saying, no, I have entered into PPA then, though I have not done anything, though I have not put up structure, though I have not incurred any money on this on the capital cost of setting up the plan, I am still entitled to 9 rupees and 79 paise because you are at default in not allowing me to finish. That's how they put their case. So pursuant to the Honorable High Court's order, my lord, annexure T, page 452 is the second show cause notice. Honorable Court, my lord, did not go into the merits naturally, my lord, because only on
That naturally.
not the ground of non-hearing. Page 452, bottom of that page, my lord, they are pointing out what are the violations. First point, on inspection date, it was observed that installation work not started. Proof of photograph is enclosed. Execution of PPA without conversion of land.
The PPA stipulates the effect of not following, adhering to the timelines.
My lord, the PPA, my lord, fixes a time frame, that's all. It doesn't say if you don't do it within that what time. Therefore, we said, you have not done it. Therefore, you don't have a right to continue to doing it. So we said we are terminating it. There is, my lord, in one of the tariff orders, the KERC says that if this generator does not complete the project, then he should not be given the tariff which prevailed at the PPA rate. He should be given tariff at the rate at which when he completes the project. Because your lordship saw, my lord, the whole object of this determination of rate is you take the cost How much did they incur to do this? Based on that, estimated life, amortization, the running cost, all that is taken into note.
Does this tariff have a final bearing insofar as the consumer is also?
Yes, my lord. What happens now is in the regulatory mechanism today, I am a distribution company. I buy power from a generating company. The generating company may be in state sector, like we have Karnataka Power Corporation, and we have many national power, thermal power corp. These are all state sector generators. And there are non-state sector generators like Jindal Power, JSW, so many of them are there. They are all set up big power plants. They are setting up plants to sell power to the distributors. So when I go to buy power from them, the regulatory mechanism requires me to go to Electricity Regulatory Commission and tell them that I'm going to proposing to purchase power from this generator. You please determine what the tariff should be. And the generator, my lord, will hear everybody, look at all the factors, because it's an expert body, my lord. There are 2 experts sitting on it. And they then determine that if this plant is set up, you can buy power from them at this rate. They approve that. I can't pay anything more than that. And without their approval, I can't buy power also. Then, my lord, this is stage 1 when I buy. Then how I should function is also regulated. What is my distribution mechanism? How much is my distribution loss? How much is my transmission loss? Can that be regulated? All of that is seen by them. Then when I sell the power, every year, my lord, I have to go back to the regulator to say, this is my proposed tariff for the next 1 year. And that is re-examined by them with reference to cost of purchase, other losses and running profit, everything. And then they fix tariff for different categories of customers. We can propose, then there's a public hearing. Everybody is allowed to participate in it. And a tariff is determined. That is the only tariff which I can charge. I can't charge anything more than that. So if I pay these people at 9 rupees 76 paise, which is going to be about 100 crores of rupees, something more like that, that is going to get translated in future into the tariff. So in other words, it is a pass-through for me. I can say instead of spending 1,000 crores, I'm spending 1,100 crores. So you please divide 1,100 crores and distribute it among these consumers. That's what is going to happen. So this speculative investor is the one who's going to benefit at the instance of this argument about their right to mean their equity, this, that, all that, my lord, is what they are now placing for consideration. Then, my lord, on page 453, at 4.5, I read 453, my lord, that was the notice. 454, he talks of power purchase agreement. And at 455, Lord, please see, what is it that they have done till the date of this reply? This reply, my lord, is May of 2017. That means 1 year has gone by. February of 16, approval of KERC was April. 1 year has gone by. Now, my lord, he is explaining at page 455. Third line now. Subsequent to issuance of commencement certificate by executive engineer, I commenced the work relating to project by cutting down the standing trees, leveling the ground, and all ancillary preliminary preparations for putting up construction to install a system. In the meanwhile, I was making arrangements to obtain financial assistance. That's important. He has not yet borrowed money. He's still in the process of arranging from the investors to invest in the said project, and was also in talks with investors who had shown willingness to invest in the project. In the said process of leveling the land, putting up fence, finding the investors and other miscellaneous works, I had lost 2 months of time. In the meanwhile, police inspector so-and-so issued a notice alleging violations committed in regard to agreed terms and conditions contained in the PPA and the guidelines. I have submitted a detailed reply to police. In the said process, I lost another 15 days' time. As such, I could not commence the work till 24/8/16. Then, my lord, in the point 2, show cause notice under reply, I have not put up rooftop construction as per building plan, which is wholly misconceived. For the aforesaid reason stated in the aforesaid paragraph, I could not commence work. Hence, the question of not putting up rooftop building as per building norms does not arise for a consideration. So this is admitted position that he didn't put up the building also.
But are you concerned with the ultimate power being, being given to the grid?
Yes, we are interested in the power.
That's ultimate.
Only question is what price.
Only on the product. But in the manner in which he generates would also be relevant.
In this case, because it is a scheme relating to rooftop, so long as he does it on rooftop, I have no problem.
This is a rooftop.
This has to be rooftop. The whole scheme is for rooftop and two-way metering.
Rooftop doesn't, in a way prescribe that the rooftop must be at that particular height.
No height restriction is not there.
But
It should-
rooftop presupposes a building and there is a roof.
Exactly. And it's a permanent building. It can't be a shed. It can't be just some poles put up and then your lodges might have seen somewhere in some areas where large extent of land in Gujarat, the world's largest solar power plant is at ground level there.
Yes.
That is because there the ground is that is in the state of in the Kutch area, no agriculture is possible. It's just barren land and hundreds of acres of land are just lying. So the idea was to use this. Another innovative thing which they did was the Narmada Canal. Now there is a lot of water evaporation that is taking place. So they permitted setting up of rooftop photovoltaic cells as a kind of a canopy over the canal. So huge, the canal is very huge. It's running into about nearly 800, 900 meters in different areas. So they made a kind of a roof on that, a structured roof, and they put panels on top. So it achieved two things. One, it achieved loss of evaporation. Two, it achieved power generation. So that was a particular scheme that was done there.
So according to you, even the generation is at the ground level. But for purpose of this scheme, you suggested only rooftop.
This whole scheme was rooftop only. And the tariff, in the tariff order, the rate at which power generation has to be paid is different if it is rooftop. It is different if it is not rooftop. Supposing somebody comes and says, I've got 100 acres of land. There's no building. I want to put up a solar power plant here. Then the tariff is different. Tariff is not the same. Then, kindly go to next to page 456, He refers to PPA section. There's no dispute on that. Para 7, It is alleged in your notice that without obtaining permission to purchase agricultural land under section 109 of the Karnataka Land Reforms Act, I have entered into PPA with Bescom for construction of STRPV, which is wholly misconstrued and untenable. It's pertinent to mention that I am agriculturist, lawful owner of land bearing survey number 485. As such, it is not required under Land Reforms Act to obtain permission from concerned department to enter into PPA with Bescom. Same was also not a condition precedent for entering into the agreement. Now, if he has to put up a building, then does he need permission? Does he need conversion? Then next para is about RR number that I have not yet obtained. I will obtain in due course. Then page number 458. He refers to the earlier writ petition. Then para 13, my lord, is where he is now talking about the cost. This assumes some relevance. As you are aware, the capital cost would be amounting to 80,000 to 90,000 per kWp for the purpose of installation of SRTPV system. Total cost for setting up 1 megawatt, which is 1000 kWp of SRTPV, would amount to 8 to 9 crores. No financial institution provided funds to process the work for reasons stated above. It is impossible for a farmer to complete the project from agricultural income. Hence, I approached many developers and investors to invest in the project. However, no developer or investor was ready to invest since there were various hurdles and unnecessary interference by the departmental officials. It is also not possible to execute the work unless there is adequate cooperation from government, your good office, and also financial institutions. Both PPA holders and officials have to join hands for the purpose of smooth completion of the project. Then, in view of the above, I request your good office to consider this reply, withdraw this notice. I've invested lakhs of rupees for leveling the land and for carrying out other relative activities for setting up of the system. However, the same will be put to waste at this juncture. And also he says at page 459, please help me to get money also. He says, "My lord, I also request the concerned officials to inform the financial institutions to grant financial assistance to me for the purpose of smooth completion of installation of system of rooftop on the building shed to be constructed in my land at so and so."
Can we have a look at the PPA?
Yes, Muna. It's there in first volume. Annexure J. Page 113. Your Lordship saw, my lord, 114, first 2-3 recitals. At 115 is the technical interconnection requirements. One 116, my lord, again, number of factors are there, safety, approvals. One 17 is commercial terms.
Now, if you see page 114.
Yes.
A, seller intends to connect and operate this for sale of solar power to ESCOM in terms of this. Intends to install, has installed this capacity on the rooftop of the premises situated at this and connected electricity. Intends to sell.
C is that he intends to sell me the power that is generated. D is that we need to buy it from him.
No, what is A contemplates is that intends to connect and operate solar rooftop.
Yes.
Solar ESCOM and no.
For sale.
If you see B.
Yes.
Intends to install, has installed this on the rooftop of the premises situated at this place.
Yes.
And connected electricity service commission bearing number RR, no site under construction. Site under construction in the same premises at this.
So the way it is drafted, it means that he is going to set up on top of the premises which is situated there.
Which is situated there or under construction.
No, there why he says site under construction, my lord, is this, that RR number is not there for that.
So it's not a building,
No.
it's not a complete building
No.
in that sense.
No. Yes.
So there is, the building is under construction.
Yes.
And I intend to install there.
Yes.
And as such, RR number, site under construction, he says. So
But there is no building. Not in this, no building under construction, no plan also, no approval, nothing is ready. His case is that I only cleared some land and made it vacant. The land, my lord, he says, there were some trees and shrubs. I cleared them, I may level the land. And he says, I spent a few lakh rupees. That's his case.
Okay. So far as building is concerned, this is the only scope.
That's all.
Sir, and construction is his output.
Yes.
Yes.
Then, my lord, is the termination for the second time, page 506, annexure U. After these hearings, my lord, one more spot inspection is carried out. That is recited also, my lord. The typed copy is at page 508. Paragraphs, the preamble, my lord, 4, 5 are all relating to. First inspection is referred at paragraph 5 on 24/8. Then in para 8, my lord, the earlier writ petition order is referred. The show cause notice reply. Kindly see para 12, my lord, at page 509. After considering the reply submitted by the petitioner, it is concluded, it is reported in the reply that they have started the work, whereas the work has not yet started as per inspection held on 24/8/16 and also on 24/5/17 by the AEE Pavagada. Proof of the photograph taken on 29/5/17 is enclosed. Hence, reply to show cause notice is not tenable. As per PPA approval letter, the validity of the PPA is expired. Also, no further time extension allowed as per corporate office letter dated so and so. We also point out that there is no conversion obtained. The photographs are from page 511 onwards. In each case, the same, each person's case, the photographs are separately them. 511 is the one petitioner. 516 is another one. 500. Lord, one more document which will assume some importance, Lord, is there is the policy of this rooftop is, Lord, in the form of a direction as to how this is to be implemented. Kindly turn to page 544, Annexure V. Your Lordships will get the entire background of why this was done. I will not read all of it, my lord. At 545, solar energy is clean energy, etc. Then third paragraph, on 10/10/13, the commission fixed a tariff of 9.56 for small solar power plants for energy generated exceeding energy consumed during a billing period. So there has to be consumption and there has to be generation both. If your generation is more than your consumption, that is when the payment will arise to them. So the whole object is that.
See that.
Page 545, third paragraph. On 10/10/13, Electricity Regulatory Commission fixed a tariff of 9.56 rupees per unit and 7.20 with subsidy on the rooftop and small solar PV plants for energy generated exceeding the energy consumed during a billing period.
So
that means the Electricity Commission said that if a person sets up a power plant on top of his roof and he generates more than what he consumes, then we will have to pay him at this rate, 9.56 rupees.
No, he generates more than he consumes.
Yes. Supposing
he sent to the grid.
That's what I'm saying, bro. Supposing he generates 1,000 units, he consumes 500. Remaining 500 comes to grid. For that 500, I have to pay him at 9.56 rupees. Otherwise, my lord, what will happen is when I consume, I'll have probably some different rates of power consumption will be there, up to 100 units, 200 units. All that won't apply. Which normal tariff would apply to a consumer of energy will not apply. Whatever you generate, to the extent you use, will reduce it from your generation, and what you feed to the grid.
Obviously, whatever he's sending to the grid only would be chargeable.
Correct. And only one, what I was trying to point out, my lord, is supposing, my lord, in my house, supposing I consume, say, 1,000 units in a month. The tariff contemplates that the first 100 units, they'll charge me at 5 rupees. Next 200 units, they'll charge me at 6 rupees. The balance unit consumption, I charge at 9 rupees.
Yes.
And progressively higher it will be. Now, for a person who opts for this, none of those will apply. It will be a flat. You generated 1,000, you consumed 500. For 500, you won't be billed at the slab rate and all. You will just deduct this and pay him for the difference, 500, which he gives me. So that was the object of all this. Then, my lord, there's a small diagram which indicates on top of a roof where the modules will be.
How is it going to the power grid?
There, my lord, on the right side, there will be a line, my lord. When I'm taking consumption, my lord, from the public line to my house, in Bangalore, they have now started underground connections. Earlier, it was all overhead. In the overhead days, from the line which is running outside my house, there's a connection to my meter. So there won't be any change in so far as that is concerned in this scheme. That will remain as it is. And there'll be a bidirectional meter. Normally is a unidirectional. What I consume is metered. In this will be a bidirectional meter. What I am consuming, what I am exporting.
How is it connected to the power grid, the grid?
Directly connected, no, just the same line.
Same line?
Yes, same line. It's the same line.
There is a meter there. How much is going to the grid?
That there's a bidirectional meter is there.
Meter, yeah.
There's a bidirectional meter. Your lordships may see the object, my lord, at 546. Objective of the program: to promote the grid connected SPV rooftop small SPV power generating plants among residential, community, institutional, industrial, and commercial establishments. Then there are a lot of technical jargon, my lord. We need to trouble ourselves with that. Please go to page 557. The norm for completion of construction was 180 days. 557. At the bottom, Roman number 7. There's at the end of it, there's an italics portion. Maximum time frame for completion of installation work in all respect by the applicant is 180 days.
180 days, 6 months.
6 months.
So within 6 months, the building need to be there. And next 6 months is the installation.
Please. In the case of existing building, he has to finish the installation within 180 days. If there was already a building, then 180 days to finish the installation.
Objective is that installation, if it is there, like that's the reason it's coincide with that 180 days.
Please do.
But even for a new building also 1 year, and you say 6 months would hold good for them also.
6 months for the installation from the building, that building construction, if you add, that's why they put 1 year. You could take 5-6 months to finish your building. Then within 6 months, you have to finish the installation. Because we are under, the whole policy is that, that they should encourage and it should come up quickly. And at page 559, your lordships will see that billing question which your lordships posed, is there. 559. The consumer, para number 18. The consumer shall receive a monthly net import-export bill indicating either net export to grid or net import.
It can be net export also,
Yes,
that he is not consuming anything.
it's possible, my lord.
Or maybe just for namesake, 1 unit.
That's possible. Supposing, my lord, they've locked the house and gone away for 3 months. So nobody is there in the house. Of course, refrigerator and few things like that will still be working.
Him something,
Yes.
least.
Yeah. And some reactive power will also be there.
That's right.
When you're not even using any of the equipment, some reactive power usage will be there. So it may be very minimal also, whatever it may be. But the object is, that would be an exception. The rule is that you are there, you are consuming power.
What is the second round of litigation?
This is the second round.
Of the litigation? How many litigations were there?
There were, my lord, at least in Gulbarga, there were 2 litigations. In Bangalore bench, there were 2 litigations.
What is the second one? First one is a show cause notice.
Yeah.
Principles of natural justice. What was the second nature of litigation?
Second time, my lord, we gave a show cause notice. They gave a reply. And just now what your lordship saw, they came to the conclusion that even now in 2017, there's no building. Therefore, you have not complied.
Is it challenged?
That is challenged in the writ petition before the learned single judge. This appeal arises from there. My lord, just to show your lordships, the tariff orders, my lord, not that I intend to read all of them, but just to show how, my lord, progressively the costs have come down. My lord, in second volume in writ appeal, my lord, that's in the writ appeal volume, 127. Writ appeal, statement of objections are in it. This relevant tariff order, my lord, begins at 423.
So we can have only 3 volumes, writ appeal 1 and 2.
Yes, my lord, this writ appeal volume 2. What your lordships are just now seeing is that set of additional documents because of translations.
These 2 volumes which you have now referred to
Yes, ma'am.
would suffice all the annexures
Yes,
which
ma'am.
have been filed.
Yes,
without
yes.
The translation.
Yes, ma'am. Page 423, my lord. They are now looking at the incentivization for the solar. At 423, they're referring to the first tariff they order, para 1, Commission's tariff order of 10th October 13.
What was the occasion for them to consider this?
Well, as a matter of policy, since the government wanted to promote solar power generation, so they approached the Electricity Regulatory Commission to say, please lay down a policy as to what we should pay. Because individual cases, instead of doing it, they said for the entire solar sector, what should be the tariff? Please determine. Because these are all incentives that were given to individuals and other entities to come and start this work. So they go into it. First time they determined the tariff in 10th October 13. Then second para at page 423. The commission in its order of 30th July 15, that's the second one, has revised the tariff applicable to megawatt scale solar photovoltaic solar thermal power plants, taking into account the significant reduction in the capital cost, especially of utility scale solar photovoltaic plants. The tariff determined in respect of rooftop solar photovoltaic and other small solar plants were left undisturbed as no significant reduction in their capital cost was observed. So between 2013 and 15, mega projects in megawatt scale reduction happened, but smaller units, it didn't happen. Then, however, in view of the subsequent discovery of substantially lower tariff in respect of solar plants where bidding tendering was adopted by procurers and also the need to revise certain norms, Commission issued a discussion paper to redetermine the tariff for grid interactive rooftop, small kilowatt case solar power photovoltaic plants based on revised capital cost and other parameters Also for revision of other norms relating to such plans on 16th November 15, inviting comment suggestions from stakeholders to be submitted to the Commission on or before 16th December. In response to said discussion paper, various stakeholders and some ESCOMs have submitted comments. Then, my lord, they've tabulated how much they have been able to achieve.
So here it remained 9 rupees.
It remained as it is in 15. No change. Then, my lord, pair 4 to 7. They are now saying that there is need to do some course correction. The penultimate paragraph or middle para, my lord, are 427. During 14-15, the Commission has noticed substantial decline in the price of solar panels and allied equipment, resulting in considerable reduction in cost of solar power generation, leading to investors offering to supply power from solar plants at rapidly declining rates. The growth of investments in renewable energy generation, particularly in the solar generation, has shown encouraging upward trend, necessitating moderation of the promotional tariff offered earlier to attract investments. As a result of rapid solar capacity addition, most of the ESCOMs have been able to achieve the present RPO targets, that is renewable power obligations. In view of these developments, Commission, in order to protect the interests of consumers, also ensures financial stability of ESCOMs, considered necessary to take mid-course revision of the tariff determined 13 in respect of solar, rooftop and small photovoltaic power plants. Commission considers it necessary to ensure that only those diligent investors who take expeditious effective steps to commission projects benefit from fixed generic tariff regime during the control period, and not those who merely express their intention to do so without taking any effective steps for commissioning projects. Then they notice their powers under section 86, 62. Then, my lord, last para in 428. In respect of plants for which PPAs that have been entered into prior to 1st May 2016 and are commissioned within the time period as stipulated by the ESCOM or commissioned prior to the date of issue of this order, the tariff as per Commission's order of 10th October 13 shall be applicable. Such plants shall be eligible for revised tariff as per this order if they are not commissioned within the stipulated time period. There shall be no extension of time period for commissioning them after the effective date of this order. So the reason, my lord, why they did this was they took note of the fact that the cost of putting up these plants, the panel cost itself came down significantly. Therefore, somebody who has not yet done anything at this point of time, if he does it in the henceforth, for whatever reason, this tariff will apply. Then they go to, my lord, the factual aspect. At the bottom of 429, they look at comments. At page 428, my lord, they say that those who have already completed, they will get it because they have already incurred that higher cost. Then, my lord, they go into all the various factors. And if your lordship should see now, my lord, at page 433, capital cost for PV modules, they have arrived at 328. Then at 434, they take note of the capital cost per kilowatt. Every aspect is examined.
The final determination.
Final determination, my lord, is your lordship should go to page number 446. Tariff for grid connected para 8. tariff for grid-connected solar rooftop and small PV power plants. On the basis of approved parameters, Commission hereby approves the following tariff.
We are concerned with
Above 500 kW up to 1 MW. Last item then. Yes. 5.20 is with capital without subsidy. With subsidy, it is 4.43.
the subsidy you give.
You can ask for a subsidy so far as capital equipment is concerned. For renewable energy, there is a policy of the government of India that somebody wants to do a project, then they get a certain subsidy.
15%.
Yes. Capital subsidy 15% on the plant and machinery. If you are spending 100 rupees, you can get 15 rupees as subsidy. Then if you get that subsidy, then your rate will be lower here because your cost will naturally be less. This order, my lord, is what you just know your lordship's perused was 16, May 16. Then, my lord, 2 years later, page 449 is 18th May 18. They take note, my lord, of further developments. At page 454, the last portion of para 11, the Commission proceeds to determine the generic tariff order for ground-mounted solar power projects capacity up to 5 megawatts and KW scale solar rooftop photovoltaic plants up to 1 megawatt. That's what I was mentioning, Lord. Ground-mounted and roof-mounted are completely treated differently in the tariff orders also.
Where did you read?
Page 454, just in the middle of para 11, right on top. The third line, Commission proceeds to determine the generic tariff order for ground-mounted solar power projects of capacity up to 5 megawatts and kilowatt scale solar rooftop photovoltaic power plants up to 1 megawatt capacity. And then they discuss, my lord, the various parameters as they've done in the past. Please go towards the end of that, my lord, at page 471. The breakup of that is at 470, how they arrive at it. And the actual figure is at 471. Order, point number 1. The Commission hereby determines the generic tariff for grid-connected megawatt scale power projects of less than 5 megawatt to 3 rupees 5 paise. These are generators, man. They are not own consumers. They set up a power plant for pure generation only as a generator. For them, it is 3 rupees 5 paise. And for grid-connected solar rooftop photovoltaic projects of 1 megawatt and below, 3 rupees 56 paise per unit without capital subsidy, 2 rupees 67 with capital subsidy. The above tariff shall be applicable to all such new solar power projects for which PPAs are entered into and approved by the Commission after the date of issue of this order that achieve commercial operation on or after 1/4/18. So a PPA entered earlier, but they're still not finished. If they finished hereafter, they'll still be governed by this. The reason being that the cost has come down.
So those who have completed and operating it, contributing to the grid, on which date, whatever is the tariff available.
Please. These tariff orders are like, they are like not cut-off dates because they are taking note of what is it that somebody will spend to put up this plant. So now they're saying, if you have not achieved commercial operation till 1/4/18, then you will be governed by this new rate that we are now fixing.
Nagaland, we'll just stop here because
Please.
my lord has a bench outside.
Please, please.
We'll continue.
Please.
Just give a date. Whatever is a convenient date, just give us. This we have heard, running a senior counsel for the Apple and Lens.
Would be 17th. 16th.
You see, we have to see.
16th is a holiday. 17th, if it's okay, or any.
It is convenient, just see it.
It's Tuesday.
What about 11th, Mr. Narayan?
11th. No? I have some problem on 11th. No? I have engagement outside Bangalore.
It will be.
12th is okay, if not, please.
Pardon?
12th is okay. 11th, one day, I'm out of Bangalore.
10th. 10th.
Yes.
So how long you will take more?
Another maximum 45 minutes to an hour.
Then we will hear
2:30.
you.
2:30.
We will fix a date for you. 10th will, we can. No, we let him complete on that.
Yeah.
Will it be on 2:30? Yeah, yeah.
Please.
Just say on 10th, 2:30. Get.
Again, my apologies, my lord. I held your lordships up in the afternoon.
Pardon?
My apologies for holding your lordships up in the afternoon.